নিউ মোশন ছিল মোশন আমার
95 in today's list, Lordship.
195. Other side has come.
My lord, we have served a notice, Lordship. I have the notice with me.
Come at 12.
My lord, at 12.
Please
Grateful.
inform the other side.
Lordship, grateful.
My lord, may I be permitted to mention
Notice group 1.
Whatever the slip.
My lord, in today's daily list, item number 18 is a corporative matter. If by mistake it has come in group 1 matter, so kindly
Item number
18, 18.
18.
Kindly keep it in the second half, 2 p.m.
Why, please wait. Let me see. Yes.
Okay.
my lord, may I be permitted to mention item number 532 of the monthly list, my lord, where my lord demolition order was passed. However, my lord, BLRO is not complying the order, taking advantage, my lord, the land of the PWD was sold to the another person. My lord, they are making further construction. Your lordship take this
All right,
matter
hand over
any
the
day,
slip.
my lord.
Hand over the
Hand
slip.
over.
Yes, call the list.
Yes, my lord.
Item number 3.
My lord, I am the petitioner. Mr. Achin Kumar Mojumdar lead this matter, paying not today only, my lord.
Lordship, this matter is ready for hearing otherwise. Lordship, the pleadings are complete. It was even considerably hard by the coordinate bench, but subsequently, Lordship, the determination changed. Now it is appearing before your Lordship. So if your Lordship may kindly fix any date
What
for
is this matter?
Lordship, this is a matter regarding that petitioner before your Lordships was suspended, was actually terminated from the service, Lordship, after a prolonged disciplinary proceeding. So now they, Lordship, challenged that disciplinary proceeding, and firstly, it was when the matter was filed. The Honorable Single Bench was pleased to dismiss the writ petition. They preferred appeal against that order, and from the Honorable Division Bench, return it back to the
Where is the order of the division bench?
Lordship. That order, Lordship, just kindly. Lordship, that after that matter appeared in the single bench, and that single bench directed to file the opposition and reply, we have the pleadings are exchanged, Lordship. It is now ready for hearing, and they also heard by the honorable coordinator. Lordship, may I kindly? আচ্ছা তোমার কাছে অর্ডারটা আছে? Right now I am. Okay. For whom I am appearing? Respondents, all the respondents.
Yes, where is your senior?
He's on the way, my lord.
Wait, pass over.
Lordship, Lordship, I apologize, Lordship. I wrongly submitted that opposition has been filed. It is not filed yet. It is ready, Lordship. It is not yet filed. I'm extremely, I apologize.
Position for what?
To the writ petition, Lordship.
It's a disciplinary proceeding matter.
Lordship.
So, can you improve upon by filing of an
But
affidavit? in
Lordship, there
opposition?
are certain allegation, Lordship, which there are certain allegation, Lordship, which you need to deal, Lordship. For that,
Have you included any document which was not part of the disciplinary proceedings?
no, but Lordship, that they tried
I'm
to.
asking you, have you included
No,
any
no, no.
document which were not part of the disciplinary proceedings?
No, Lordship. Certain documents we have incorporated, Lordship. One
Which were
document.
not part of the disciplinary proceedings.
No, it was in the disciplinary proceeding, but these documents are perhaps not part of
What
the
are those
writ petition.
documents?
This is only, Lordship, that one service particulars, Lordship, to show that, Lordship, we have taken one jurisdictional point, Lordship. As
Service particulars was part of the disciplinary proceedings matter in an inquiry.
no, Lordship, this is not, Lordship.
I'm
Lordship,
asking
just
you, have you included any document in the opposition which were not part of the proceedings before the inquiry officer?
no, Lordship, nothing new, nothing, no.
So this document was not part. Why have you included that in the affidavit?
Because,
opposition?
Lordship, we have taken the jurisdiction point, Lordship. They filed it.
Sir, the documents which were not part of the proceedings before the inquiry officer and the disciplinary authority cannot be looked into.
No, but Lordship, this writ petition ought to have been filed in before the Honorable High Court Patna, Lordship, because the jurisdiction lying there, Lordship. That point we have taken to only to corroborate that, Lordship. We have enclosed one documents to show that, Lordship, his native place and his altogether service was there. He just here tentatively was maybe the staying here in Kharagpur, which in the cost title, Lordship, they have showed. But he otherwise he was staying there, and that initially also they have filed a writ petition.
Charge sheet was issued with regard to an action where when he was posted here or in Patna.
In Patna, Lordship. In Patna, and subsequently that he has been transferred.
Point out that fact to the Honorable Division Bench when this matter was before the Honorable Division
No,
Bench.
Lordship, Division Bench has not gone into the merit, Lordship. Only that
It's a
return
question of
and because that,
jurisdiction.
Lordship, that might,
It's a question of jurisdiction.
yes, but Lordship, that
How can I now overcome that?
Lordship, may kindly appreciate one thing, Lordship, that the
Sir, please consider the division bench has remanded the matter to the single bench. And you have not raised that point before the division bench. What prevented you from taking that point before the Honorable Division Bench? It's
But
a question of jurisdiction.
But what happened, Lordship, may I submit for only one line, Lordship, that in the writ petition was dismissed on the first instance.
I
So that's why they
appreciate
preferred, and
So thereafter in the appeal when it was remanded, you are present. You represented the authorities. You
yes,
also
yes,
pointed
in the
out
appeal,
that this-
appeal I represented.
so the jurisdiction, this court do not have jurisdiction. Then it could not have been remanded to the single bench.
Lordship, in that case, we will argue the matter on other merit, Lordship. But in the coordinate bench directed to file the opposition, Lordship. There is an order in that respect, Lordship.
You have filed the reply.
Yeah, they have filed, Lordship.
The affidavit in opposition filed by the learned advocate for the
Lordship, any day.
after 4th May.
Any day, Lordship. Sixth.
6th May,
I'm grateful.
on the prayer of the learned. So direction, so this has to be, now you are taking time. The division may directed to here, now you are taking time. So it has to be on record. Yes, next. Same heading as well. Yes, next.
I am for the petition, but I am praying for leave to withdraw with liberty to file afresh because
Why? What is the technical defect? For
some
which you
develop,
want to withdraw?
after filing this writ petition, some development is there. Not
What is the development?
a PIL was filed before this honorable court against the petitioner on the basis as per order of the division bench. The DM passed an order. Now we have obtained certain documents from there.
DM passed an order under 10-4.
Not as per direction of the
এটা আমরা আছি
DM
Honorable
passed.
আমাকে তুমি মেনশন করেছিলে আমাকে
What is the challenge? What do you want here?
but this is for compensation.
A
কম্পেনসেশন পাবলিক ইন্টারেস্ট লিটিগেশন হয়েছিল
No, what happened after that?
After that, my lord, DM passed an order, my lord, and on the basis thereafter we have obtained certain documents, my lord, which we need to
Passed an order
to
rejecting
the-
your claim.
No, my lord, that the
It is the order of the DM.
একসাথে দুজনে দেখিয়ে কি করব তুমি তো আর বলনি আমি তো ফাইল আনিনি
Please give me the order.
একটাই কপি জজেরও একটাই কপি
just
So you filed this writ petition for a direction upon the district magistrate to consider your representation.
yes, my lord,
In the meantime, it has been considered.
not considered, my lord. Some other person filed a writ petition alleging that I am occupying the government land, my lord. On the basis,
Now you want to challenge this.
yes, my lord. Thereafter, we also obtained after filing RTI application, we have also obtained some certain documents, my lord, from which there is a
The
contradiction. as
learned
regard-
advocate appearing for the petition. You did not miss this matter. Yellow? Subsequent events cropped up. Yes, ওটা দিয়ে দিন। আচ্ছা ওটা লিখে দিন। মিস্টার ধল Yes, next.
পাবোই না এমনিতেও পাবো না
Wait, please, my lord, I appear for the petitioner.
But in this matter, I'm appearing for the state in this matter, my lord.
Yes, Mr. Ahmed, why are you not appearing? Yesterday it was taken up. You did not
My lord,
appear.
matter yesterday, my lord, I must have missed it, my lord.
Yes.
Uh,
Yes, what do you say?
There's one difficulty, my lord. My junior has not come who has the report with him, my lord. That's the difficulty. So,
So when can you file it? 30th?
I do have
30th, my lord. Or it could be, my lord, after elections results, my lord. That could be much better, my lord.
I'm suffering entirely
At a stretch,
from
my lord, this thing is going on, my lord.
What can be done?
because this was to be submitted in the month of November.
Mr. Ahmed,
Fourth, he'll be out for some procession.
fourth is after election
He'll
or
be
after
going
the
out for a
result.
procession.
6th করে দিন।
I'll be seeking, my lord, that limited stay be there, that the
For what?
construction is going on, my lord. The police is effectuating construction on the property.
What is the extent of the construction?
My lord, this
If
was
it is demolished, entirety will be demolished.
this was the situation when the writ petition was filed.
So by the time
Now, my lord, if they are taking the time, I should give some relief to my client, my lord. Kindly understands my predicament.
fixing it on
And this is the condition right now.
6th under the same heading. Yes, next.
Grateful, Your Worship.
Lordship, item number 6, Lordship, I am for the petitioner. I am not press this application. Petitioner is not willing to press this application, Lordship.
Where is the written instruction?
The written instruction is handed over by my junior, Lordship.
The learned advocate appearing for the petitioner. Yes, call the next matter.
I am appealing for the petitioner.
The state
Yes.
matter.
Kindly see order dated passed by your lordship first 9th February 2020.
There is a direction of filing an affidavit in opposition, my lord. It is ready, my lord, yet to affirm, my lord. Kindly fix it 2 weeks, my lord.
2 weeks.
It is ready, but we could not affirm the evidence.
Ready, please affirm.
Yes.
Don't take 2 weeks.
But,
If it is ready, why are you taking 2 weeks?
the officer is not been able to come, my lord. That is why.
They will not be available for 2 weeks.
Next week, my it will be affirmed, my lord. And kindly fix it after.
The learned advocate. Yes, next.
Yes.
Yes, Passover. Next.
Well, extension. Well, we have served.
Petitioner,
Yes, I am for the petitioner.
what
Well,
is the matter, Mr. Dor?
this is, well, state was granted lease in favor of me initially, and
It was
then,
granted lease.
yes, it
Why?
was a land of the state. Then state has granted long-term lease in favor of my client.
You said state was granted.
No, state has.
But
No, sorry, my lord. State has
why
granted.
I was thinking you have granted lease to the state.
No.
Yes, now
Now,
who is for this state?
my lord, Mr. Shane, my lord, we have given him a copy.
Have you informed him that you
Yes. My lord, I have given the notice.
Mr. Dor? What is this?
This is the notice, copy of the notice.
Copy of the notice is taken on record. Yes, next.
नाइन तो होगा ना बाबा नाम पे लिखिए नाम पे लिखिए
তাহলে 9 এ
June and month.
non-appearance. Yes, Mr. Basu.
yes one can extend the entry order and fix the date for hearing
What is this?
reply
Reply. What is this matter?
matter is very short lease was granted to me within a specific time I have to construct time lapsed they are not revoked ultimately you will approach your lordship's court your lordship
KMDA.
no this is Asansol Durgapur Development Authority
All right.
thereafter your lordship's court ask us to file a comprehensive plan how you will complete the construction without considering that my lord in spite of the lordship's order they have passed an order we approach your lordship's court again remanded back now the second round of litigation where without considering this plan is must be for the purpose of giving a time to construct they say yes plan is there but you have not obtained the sanction plan unless you give me sanction I can this is the short point
Where is that order?
third party is not here state is not here this is
It is
resolution
the answering respondent.
is party
Where is the impugned order?
oh বিরাট বড় অনেক বড়
Page 212.
ভাবলুম করবো না তে করাবে তো to appreciate my lord the without going to the impugned order your lordship kindly go to the order of justice sent otherwise my lord it will be difficult
So you are directed to show cause only. You are directed to show cause only. Page 217.
kindly see that's why I say kindly read the order of justice sent what should I show cause that stage is over then your lordship directed me to file a comprehensive plan
The affidavit in reply filed in
relax
only basically you'll be
corridor
having
corridor is totally empty
two
corridor is totally empty
2 working weeks, Mr. Basu,
yes,
you will
that's
be
true
having.
Streets are empty, corridor is empty, everything is empty today. Everywhere.
Yes, next.
Pocket is also empty. Pocket is also empty.
no
Rightly
who is saying
said.
this
My lord, I appear for the petition. My lord, this is for extension of interim order that my lord West Bengal Inland Fisheries Act matter, my lord. Assumption of jury. Mr. Kaur had moved the my lord petition, and lordship was pleased to pass an interim order.
Any directions for affidavit?
Lordship directed to submit the report. I am submitting the report. I will hand over to my lord, my
If we
friend.
get a copy, we can, if we want to take
And
an
it's a
exception.
very short issue now. It is, my lord, against the order of the appellate authority. After our action, my lord, matter was taken to
Mr.
the.
Ghosh, what is that issue with regard to that notification in the inland?
But I have given my
fisheries?
lord all details of the
Document.
things, my lord, in this my lord case.
My lord, maybe get
Two orders are there. two orders are there. Therefore, I have given my lord the orders, notification, whatever it may be, everything has been given.
We need not
And
trouble
at
your
the
lordship,
end
my
of
lord,
the
with adjudication of this issue, my lord, if ultimately lordship holds that the assumption of jurisdiction by the authority was
my
wrong,
lord, I am submitting, my lord, at
and
the
if
end of the
everything is
day,
remanded to the first
my
authority.
lord, at the end of the day, my submission would be, my lord, if he inclines to take the pond, I will have no objection, subject to his maintenance properly.
I'll inform Mr. Kaur, my lord.
Well,
Mr.
that
Ghosh has
issue,
not
my lord, to
submitted.
be, because in all cases, my lord, I'm taking this stand because, my lord, it is not, my lord, my lord, the luxurious thing, my lord, to take over the management control of anybody's property, provided he maintains it properly.
It's a water body.
My lord, they have, my lord.
I have
whatever
given the
documents
picture.
that
I have
they
given the
given,
picture, the
it was-
total area.
It was shown as, my lord, their cases.
So
it
you are
was shown as-
not admitting that it's a water body.
My lord, not in the, my lord, unless I see the, my lord, report of the, my lord, corporation, I cannot. Because, my lord, my challenge here was that the assumption of
No, that's
jurisdiction
on law
by the
point.
first authority.
That's on law point, on facts, whether it's a water body or not. There cannot be any dispute with regard to that. If it's a water body, yes, no, there cannot be dispute
My lord,
on
there is,
facts.
my lord, there is, my lord, a slight dispute here because it was, my lord, always, my lord, shown as, my lord, land area in the, my lord, records. That is the, my lord, confusion which is, my lord, created.
That
So
is
you
not
are
Kindly allows us to
well,
look
that
into
is
this
that is
report.
not the thing,
So
my
you are
lord. Let him
disputing
go
that
through
it's
the my
a water
report.
body.
Yes.
Well, I'm submitting, my lord. That is not the issue, my lord. His objection was that he was not given a hearing.
No, my objection
The
was
testing
not that.
issue was there.
My objection was that the first authority could not invoke 17A proceedings, my lord, because the provisions were not,
No,
my
that
lord,
was
attractive.
not the case, my lord. I submitted. Now he is developing.
I will show it from the
Well,
grounds itself.
the report, you go through this report.
My
If
lord.
you want to file any exceptions,
Well, I'm submitting, my lord. Let him exception or whatever, my lord. It may be. But in the month of May, my lord, before the vacation, my lord, takes up as for order, and it is short issue because primary authority and
appearing under the heading for orders.
but it is in the list, my lord, for
Today, it is under extension of interim.
No, today it is
no,
under
no.
the extension. Before that, it is
As a
appearing
motion, my lord, it is still there.
It's
It is
under the heading.
motion, but it is not.
So let it retain its position in the
My
list.
lord only gives
But
me
it
2
is,
weeks
it
to
is
take an
much, my lord, the bottom position.
Mr. Ghosh, I am adjusting this. Some group I am upgrading one day, another group I am upgrading. That is why on one day we will be finding this matter at the bottom, the other day it will be slightly higher above. So that is why I am reshuffling those so that all groups can be touched. The report filed by the Kolkata Municipal Corporation.
Number 12.
Item number 12, Mr. Anup
Time
Das.
for petitioner by
Uh,
listener is appearing virtually.
Mr. Anup Das Gupta appearing for the private respondent. He cannot attend the court for his father illness. I am praying for not this week, my lord.
For extension
Today
of
is for extension.
I am for the state one.
Kindly see the last order dated, my lord, 20th March of 2026, my lord.
An accommodation has been sought for on next. Call the list.
My lord, I am for the petitioner.
For the state.
Submission.
You have solved.
Yes, my lord. I have solved.
Yes.
My lord, the petitioner purchased a plot of land and subsequently recorded their name in the record of right. My lord, herein the private respondent made a unauthorized encroachment over the government land in front of my land. I have made a representation on 2nd March 2026.
Who is for the state?
But no step has been taken, my lord.
Who has been engaged for the state?
I have served, my lord.
Today.
My lord.
Pass over.
Item number 14.
Here.
I am appealing on behalf of Union of India.
The petitioner, my lord.
India.
Yes, my lord.
Any private respondent is there?
No.
Yes, what is this?
But petitioners,
I am for
State, you are for the state.
Mr.
All right.
Day is separate. My lord, petitioners are the owner of certain plots of land, my lord, which has been described in paragraph number 2. By inheritance and by, my lord, estate succession, that probate granted in favor of them. Sometimes in the year 2013, my lord, a notification under section 20A of the Railways Act, my lord, published for, my lord, taking of the certain lands for, my lord, railway project. Your lordship will find it. It is at page annexure P3, page 32.
32.
Page 32.
Yes. Then what happened? What is your grievance now?
I'm coming, my lord.
Yes.
This, kindly see, my lord, 1236. Middle portion of this, my lord, column. Middle column.
1246 or 36?
1236. This is the
Yes,
plot.
36, yes.
The land, my lord, acquires is 0.360. As your lordship got it, my lord, 360.
0.360 or 390?
390. Sorry, my lord, 390. Sorry. 390, my lord, kindly sees the award pass, my lord. Your lordship will find is at page P7, page 47. Annexure P7, page 47.
Yes.
0.29988.
Page 47.
47. Bottom portion, my lord.
Yes.
Land area also describes 0.299988.
Yes.
That is small, my lord, then, my lord, acquired land. So, my lord, even then, my lord, till date, they have not disbursed the, my lord, compensation amount. I don't know, my lord, whether, my lord, railway authority has, central government has disbursed that amount to the state authority or not.
So far as I have no instruction, kindly give me 2 weeks time. In the meantime, I will take instruction.
2013, no, my lord, notification. If it is not, my lord, disbursed in favor of the
Yes, sir,
state,
what is your instruction?
acquisition will go.
Instruction has come, my lord. My lord, he filed an application before the authority. My lord, that will be considered by us. That is, I am the, my lord, competent authority.
At first, you ascertain whether amount has been
If, my
disbursed or
lord-
not. Then, my lord, acquisition will go if it is not disbursed.
There is no such provision. Huh?
Yes, there is a provision. Kindly go to the Railways Act.
Application
1249. 1248.
20.
50. Application করছে আপনাদের কাছে।
So there are several plots for which you have made this representation.
Yes, yes, several plots, my lord. Land described in, my lord, para 2, my lord.
Paragraph 2.
Paragraph 2. And the paragraph 4, my lord, is land those lands have been acquired.
All right, so let the special land acquisition officer take a decision on this.
Yes, madam.
My lord, kindly consider if it is not disbursed, then my cause of action will first stand because
Yes. So let them take a decision.
they will come with the report. That will be better, I think, my lord. Subject to my lord, your lordship approval, they will come with a report whether it has been disbursed or not. Then, my lord, kindly refer this matter to the my lord for disbursement. My lord. If it is disbursement of the amount, only that
can be done. Let them take a decision. Otherwise, it will be unnecessarily kept pending here.
even my lord, if my lord, it is if the my lord amount is not
Report,
disbursed,
then exceptions to the
again,
report.
my lord.
Then hearing, nobody knows when it will be taken up. Ashwin.
Number 15.
In
Milord, item 15, Milord, I am appearing for the private respondent. Only, Milord, today I received the brief. If your lordship kindly accommodate.
Let me see. Yes,
Lord,
what is this?
The petitioner is the owner of a plot of land which is just adjacent to the road and Malal unit. Malal, the unauthorized construction has been made by the private respondents. Admittedly, Malal, previously 144 proceedings was initiated. In respect of that, Malal, an inquiry was conducted. Kindly have a look, Malal, page 35. Malal, 35 and 37. Malal, the report and Malal, I am seeking Malal, after this, Malal have made an application to remove that, but that has not been.
Where is your application for
Malal,
removal of
application Malal, last Malal, just
subdivision officer?
yes, yes, Malal. Page 40.
42.
Yes.
Yes.
My lord, I'm praying for some time to take instruction.
Yes, what is the instruction?
Milord, since Milord, only today I received the brief. So far, Milord,
I'm directing them to consider this.
and Milord, kindly regard my submission, Milord, that the land, the building of the private respondent is situated in his own, Milord, on land, Milord.
On Rayati property.
On Rayati property, he purchased that.
You have not encroached upon any
No,
portion.
no, no, Milord. And Milord, they have constructed illegally their building. The petitioner, Milord.
Illegally on their plot or
on their plot, Milord. Kindly regard this.
Mr. Banerjee.
Lord, what your lordship is saying, Lord, I have not heard. That's why, Lord.
A representation has been made alleging encroachment upon the public land. You initiate a proceeding. You inquire into the matter. If there is encroachment,
Representation consider if it is there.
And remove
Yes,
it.
yes. If it is there.
And Milord, the 144 report, the inquiry report, Milord, arising out of 144 proceeding, Milord, is under challenge in a Milord revisional application. That is pending, Milord.
Petitioner.
The plot number one or the 104.
104.
Yes, yes, ma'am.
And what is this public land? Which plot?
140, my lord. That is my lord.
140.
Yes, yes.
Which paragraph you have stated?
That is my lord.
Sir, sir.
I am the owner of the plot number one. Paragraph 2 is my description.
Yes, that I have got. But where you have stated with regard to the Noyanjuli? Plot number you have not mentioned.
Yes, yes, my lord. Page paragraph 7, my lord.
7.
Yes.
LR plot number 140.
Yes, yes, my lord. Recorded in the name of Gram Panchayat, my lord. I have already annexed, my lord, that.
The petitioner claims
first page, 39, the
But the
petitioners
police were
agreed.
directed only to
No,
no breach of peace.
petitioners is aggrieved by the fact that the private respondents are raising construction in such a manner that the egress and ingress of the petitioners become obstructed.
Yes. Yes,
Now,
but-
now, my lord,
and there was an allegation of assault also, for
yes.
which there was
Yes,
said that
that's right. But your lordship has already dealt with.
Kilo? Affidavit service taken on record.
Obliged, sir.
Item number 60.
Lordship, I am for the petitioner.
Petitioner.
Lordship, I am for the private respondent number 9, Lordship. My
You are
senior
from the state, Mr. Vijay. Yes.
Lordship, on Mominul Haq, Istata construction over PWD roads lands. For
Yes.
that petitioner made a representation and a writ petition has been filed. After hearing that writ petition, your lordship has direct the authority to demarcate and take decision and consider my representation. On days before that order, your lordship, that Mominul Haq hand over this building to this private respondent, your lordship. I went to the concerned authority and disclosed total fact, your lordship. That authorities said to me that this private respondent name was not added at that writ petition. For that reason, they did not take any steps against this private respondent. For that, I made again a representation before the authority
That representation has not been considered, and for that I filed this representation, Your Lordship. My representation is on page number 19.
Yes, what is your stand?
My lord,
Your
Lordship.
Virtual, Your Lordship.
Yes.
Your Lordship, I beg to appear on behalf of the Your Lordship respondent number 9. Since
Yes.
Your Lordship, I am suffering from Your Lordship the pox, so I couldn't be able to Your Lordship present before Your Lordship. Since Your Lordship, the private respondent is the absolute owner, acquired the property by the virtue of a deed. The deed is there, and he acquired the property, Your Lordship. He got the property, Your Lordship, in possession in February February in this year, Your Lordship, 26th of February in this year. The total of plot is, Your Lordship, 95.95, Your Lordship, the Shatak. And the petitioner, the private respondent herein, is the owner of the plot, Your Lordship, by the virtue of a deed, is, Your Lordship, 0.00 point, Your Lordship, 305. That's mean, Your Lordship, 3 Shatak. The entire record is there, and there was an order of the Your Lordship, the coordinate single bench on earlier occasions that appear, Your Lordship, in the page number 16. The petitioner, the petitioner, Your Lordship, did not even stated the fact, Your Lordship, that the private respondents in which portion of the plot he had acquired. There is no as such pleading, Your Lordship, in the Your Lordship petitions, stating, Your Lordship, that stating the fact that the petitioners enclose the property in which side. Since, Your Lordship, the petitioner are the absolute owner, their name is also reflected and recorded, Your Lordship. The earlier owner name also reflected, appearing, Your Lordship, in the page number 7. Last name, Your Lordship, the Mominul. He was the Your Lordship, the earlier owner, from which, Your Lordship, the respondent number 9 got the property.
My lord, Your Lordship, kindly come to the earlier representation, page number 13. My lord, my learned friend has submitted one mention before Your Lordship, saying that this Muminul Haq, son of Azahar Sheikh, and my lord sold the property to the present private respondent. Well, that version is never, that version, my lord, that content is not there in the said representation. There, his particular allegation is against my lord Munimul Haq, son of Azhar Sheikh, who is, my lord, who has constructed the building in partial portion of his own land, in, my lord, as per his allegation, in partial portion of the government land. Your Lordship, in the said division, directed the concerned, my lord, state government to make the demarcation. Here, my lord, here
You have made a demarcation.
my lord, demarcation, my lord, has not yet been done.
Why have you not made a
my lord,
demarcation?
only, my lord, I have received the police report. My lord, demarcation regarding that, my lord, case, my lord, has not yet been done by or
What does the police say?
Police report, I have got the police report just yesterday. And whether demarcation has been done, that is
How
what I
soon
don't.
can you make the demarcation?
My lord, now his allegation is reviewed hour.
All right,
That person.
I'm not concerned about who is there. Please make a demarcation. Find out who is in encroachment. Remove all.
Then, my lord, I will.
Whether it is Moinul or it is Moinul,
Kindly, my lord,
everything.
demarcation is not there.
Yes.
It's not made there.
Demarcation, when can you make that?
Kindly give me, my lord, 15 days or 1 month time.
15 days, yes, I am giving, because you have got from February, you have got sufficient time. So I can give you 15 days time. So make that and submit a report by 15th.
Yes,
15th, submit a demarcation report. What is the civil suit pending?
No civil suit.
459 of 2025.
25.
Who has filed the civil suit? You have filed.
No, Lordship.
Your Lordship, one civil suit is pending between, Your Lordship, the respondent and the petitioners. The petitioner is also party there in the suit.
Who has filed?
That the earlier respondent, Your Lordship, the earlier owner of the plot, he had filed the partition suit, Your Lordship, the civil suit before the concerned criminal civil court having jurisdiction. But, Your Lordship, the fact is that the private respondent and the petitioners, there was an enmity between the private respondent and the petitioner, Your Lordship, as a result of which the private respondent petitioner filed this suit, petition, Your Lordship.
Upon the
special diary.
Yes.
একটা রিপোর্ট দিন দিন
Please adjust the microphone.
Service not yet been affected by private respondent. So
You are appealing for
I am saying
For the state.
state.
not this week.
The learned advocate appealing for the petition. The petitioner shall
Not yet.
same.
Already done.
Next same order.
Item number 18, Lordship. 18, my lord, I am the petitioner.
My lord,
This is a group
I am
5
led by
matter, my
Mr. Amarendra Chakraborty, my lord.
Number
He is
Item number
18,
my lord.
my lord.
18. Yes.
This is a group 5 matter. Kindly, my lord, let it be taken up at 2 p.m. I am being led by Mr. Shomam.
All of you are here. You can start.
My lord, respondent number 3, 4, and 5, Amarendra Chakraborty is not present for his illness. My lord, kindly fix it after a week.
After
After this week, my lord.
The learned advocate. Next.
Grateful, Lordship. Item number 19.
I am appealing for the petitioner.
The state.
Yes.
Acquired in 2013, my lord, for the construction of the Arambagh Boychondi new broad gauge rail line, my lord. And thereafter, my lord, my compensation has not been disbursed. Thereafter, my lord, I have made a written representation to the concerned authorities, my lord. But despite receiving such written representation, my claim is pending, my lord. If your lordship kindly come at page number 64, that is the impugned notice, my lord.
Who is appealing for railways?
The service has been affected.
Not today. Next.
monthly list, item number 560.
Petitioner. Who is for the state?
Mr. Mahato is appearing on the last.
So Mahato is there.
I think little bit change. Little bit change.
But who is for the respondent number 7?
This is the very good.
Yes, Mr. Mahato, you are there. Your name is appearing in capital letters.
And my lord, prior to application, I have already submitted.
The respondent number 7.
My lord, respondent number 7 was here. My lord, respondent number 7 was on last time. My lord, he was here.
Who is respondent number 7? Bhavadipati Jila Parishad. What can be done today?
My lord, kindly fix the date, my lord. Otherwise, my lord, my only grievance is that, my lord, regarding the unauthorized.
You have taken a resolution today. What can be done? Not today. Next. Next.
Item number 562.
Yes, Supratim Das sitting there.
কত number?
Not paying compensation and sitting over there. Pay compensation. ফাইলটা দেখান। Yes. Yes, yes, call the next matter.
Now I can recollect.
Yes. Pay compensation.
There is an order passed by my lord on the self-same land acquisition case. Already my lord has passed an order
Directing?
where directing to pay the compensation.
That is why I told you, pay
Yes.
compensation.
Perhaps Mr. Pan appeared.
You are for the petitioner in that matter?
No, no.
Yes.
Daily list item number 20.
Yes.
মামলাটা ধরেছিল তোমার হয়ে আমি বলে দিলাম।
Well, I beg pardon, Mona, because I'm coming from court number 28.
Any private party is there?
No, no,
no private party.
Mr. Banerjee is talking about the previous matter.
That's 562 Mona. But
No,
I
I'm
don't
saying
have-
any private party is there in
No,
that
there is no
matter.
private party.
Then
No.
I can take it up after this.
Yes.
ওইটা 562 টা ডাকবেন এইটার পরে। Yes, who is appearing in this matter? You are appearing.
Appearing of addition of party.
Addition of party, why?
On the basis of his complaint about the encroachment, the proceeding had started, but the writ petitioner never bothered to made him a party in these proceedings. Subsequently, he has come up with one application for
petitioner?
addition of a petitioner will not come because on the last occasion, petitioner has submitted that he was not given any opportunity about the notice of inquiry. He was not present at the time of inquiry, whereas my instruction says he was given a notice, he was present on the day of inspection, and he has signed a document, everything. ও আর আসবে না তো, ও এখন এই কটা দিনের অ্যাডভান্টেজ নেবে।
None appears for the petitioner.
But in the next,
Item 562 monthly list.
Yes.
স্যার একটু ওই যেটা পাস ওভার হয়েছিল সেটা।
He has left. All right.
Yeah.
Yes, call the next matter. Sorry.
Our list.
কি করছি brief আসেনি? Brief আসেনি, brief আসেনি।
It has come or has not come?
Yes, come. Brief has come. Yes.
এরপরটা থেকে
Coming.
Yes, 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 yes.
All right, let it come. Yes, call the next matter.
ও একটা আছে একটা। হ্যাঁ আছে একটা।
Item 21.
Well, in this matter, Lordship, my lord, passed an order on 5th of January, challenge, my lord, against the resolution of the water body management, whether the pond is there or not. Your Lordship asked me, my lord, to produce two documents. One, my lord, the assessment record, and also the NRS map.
I direct you to file the report.
And not report, two documents Your Lordship required
Documents.
to submit by an order.
The NRSA aerial map and the IB copy.
Yes, my lord. I'm placing this, my lord. If the petition is not there, I'll serve a copy to him. The two documents as required by Your Lordship's order, the 5th of January.
It's legible, Mr. Ghosh.
My lord, I see that some of the eligibility is there so far as the assessment record is concerned. Well, I will require on the day matter will be taken up. My lord, for my lord,
the type copy.
Yes, my lord. That I'll provide my lord, at the time of my lord, consideration of the matter.
Pursuant to the order dated the within the time limit mentioned here. 14. Yes, next.
নামটা দিলাম এই এটা স্লিপ দাও তো একটা নাম দিই বাবা
None appears for the petition.
For the petitioner, my lord, this is the affidavit of service. My lord, the factual backdrop of this case, my lord, the petitioner.
No factual background. Other side is not there. What you will do with the factual background? Yes, please take it back. Yes, next.
Item number 23.
As a lordship, please.
23. Upon that 23, I'm for the.
Item number 23, I am for the petitioner. Advocate and advocate is suffering from highly fever. He did not come to.
Not this week, Kordi. Yes. Yes.
Several occasions they did not appear in this matter. Earlier occasions, several times they did not appear.
So you have taken a resolution, sir. What can be done? You will be taking resolution and on the others.
Open my mouth, that's all.
Mr. Banerjee is keeping quiet. He's asking whether his name is to be given or not. Yes.
Item number 24.
I am appearing for the petition. I am appearing for the petitioner. The supplementary affidavit has been filed as per direction of the Lord.
Nobody dares to oppose you, Mr. Mistro.
Nobody
Look,
is coming,
nobody is
Lord.
there. Mr. Mahato is sitting at a distant place.
Lord, it is
Cannot come closer to you.
the matters relates to the land acquisition. The already
What can be
central-
done? Who is appearing for the state?
Dheeraj Trivedi already appearing.
Who is appearing for the state?
State is not involved, Lordship. Central.
Central.
Railway Authority acquired my property
Yes.
without compensation.
Pass over next.
Item number 26.
26 are for the petition.
Yes. So Dhar, you are for the state.
Yes.
Any private party?
Yes, yes.
Election, my lord, to file a report.
Well,
Because
the
that
report
is a-
has not come because there is no reflection regarding the acquisition. At least in my record, that is overlapping register. Now we are trying to find out from the other sources, from the requiring body, for whose purpose the land was acquired. Now private respondent has come. So anyhow, my lord, I need some more time to come up. Well, minimum 8 weeks at least.
8 weeks.
Yes, because we are not getting anything regarding the acquisition.
Record shows my lord, 1 year back my lord, report was directed to be filed in the year 2025.
তারপরে তো রিপোর্ট ফাইল করেছি।
না,
হ্যাঁ।
হয়নি। না, হয়েছে।
ধ্যাৎ, দাদা কি বলছো? হ্যাঁ, তাহলে
কপি না রিপোর্ট দিতে পারছে না, তুমি বড় রিপোর্ট হবে না।
এলে যশ একটু দিন না দাদা।
The undersigned is requesting for providing a certified copy of the REIT. এটাই তো নাকি? 8 জুলাই
23, 25, নাও 26 এর একটা রিপোর্ট এন বাবা, না হলে আপনারা আবার আমার ঘাড়ে দোষ দেবেন। নিন ধরুন।
All on it.
কিঙ্কর ভট্টাচার্যের নাম দিয়ে দিন।
Item number 27. 27, I'm for the petitioner money. But earlier occasion, my lord, Lordship is directed to file a report.
Passover, next.
But this is the fourth time.
আরে আজকে নো একবার
Item number 562. Only not today, man. I beg pardon, my lord.
Yes.
My lord, better, my lord. Completely covered by your lordship's order, my lord, my judgment, my lord. In respect of Tulika Chaudhary case, my lord.
Tulika Chaudhary.
The same acquisition case, same plot. After producing the record, my lord, your lordship being satisfied that award was not passed and it has been sent for recasting. That's why, my lord, if your lordship come to your lordship's judgment, paragraph 19 to 22.
19 to
22. The lordship categorically stated the reason.
এখানে একটু দেখি কপি দাও।
And thereafter, your lordship,
yes, it's a
opinion.
Yes.
For page 20, paragraph 27.
Kindly,
Well, same acquisition case,
but perhaps different plots.
Your stand is the same.
Same is.
Yes.
Declared on 29th of March 2000, but
just sent for recasting.
So I'm following this judgment.
The new instruction has come. I must also.
Well, this is the second round of litigation. They have
end up this.
on the ground of
Copy instruction. They wanted to raise the point of Digambor Chatterjee's judgment has been relied.
What is Digambor?
Don't ask me, man.
That is,
it's very difficult for me to even support.
What is Digambor?
Delay.
But not Digambor Chatterjee.
Sorry, Digambor Misra.
Digambor Chatterjee.
It rang the bell of somebody else.
Yes.
But this is the second round of litigation. My lord, the
আরে বাবা চুপ করো না, আমি তো তোমারটাই শর্ট করে দিচ্ছি রে ভাই। ওফ, ইনস্ট্রাকশনটা কোথায়, আমি কি দেখে বলবো?
Oh, this is University of Delhi.
Yes. No, next one. Murad will find the Digambor From the Supreme Court website, there is another judgment.
No,
What has
but in
got it?
is it challenging the order dated 16th of March 2025?
Yes, Lord. 11th March 2025.
Oh, this.
What has got it?
Well, they have thrown two judgments, one Delhi University and one Amar Kumar Das.
Yes.
Yes.
But that is
So,
not.
Those are on service jurisprudence.
Yes, my lord.
As also Digambar is there, my lord.
No, Digambar is
If I am not,
we are delayed.
if আরে বাবা আমার ইনস্ট্রাকশনের মধ্যে ও
Amar Kumar Das.
What is your postcard?
করবে একটু আমাকে গুলি দিচ্ছ একটা ইনস্ট্রাকশন দিয়েছে দেখো তো দেখো তো পড়াশোনার কোনো ইচ্ছাও নেই দেখো তো পুরনো
Well, in the instruction, my lord, they have annexed the Amar Kumar Das.
হ্যাঁ করেছি তো এটা আমার ইনস্ট্রাকশন যেটা দিলাম ওপরে দেখি দাও আমার কাছেই নেই আমি দিয়ে দিলাম জজ সাহেবকে দিগম্বর দিয়েছে তো মানে স্টেট অফ মহারাষ্ট্র ভার্সেস দিগম্বর ইজ দেয়ার and Omar is also there. Kindly peruse those judgment and then
You appeared in that matter. Why I distinguish this Digambar? Give me that judgment. Because this is, where is that? Sapan appeared in that matter also, I think 1 month back.
Even Mr. Mahata had relied on Digampur and that has been,
I think
yes, that has been also.
Constantly, Mr. Mahata, you have relied
তুমি
upon
যেটা
this.
রিলাই করেছিলে দিগম্বরটাকে ডিস্টিংগুইশ করে দিয়েছেন জজ সাহেব
What is the Constantly?
No, I was not there.
Yes. You
কি
appeared.
বলছো
Mr. Owen Banerjee was also there.
Owen Banerjee there. I am not there. I am not there.
তুমি নিচে নেমে
It
বললে
was
না
your book. You brought that book and you have handed over to Mr. Banerjee.
I
He
have
relied
brought
upon that.
I have brought that book and my petition I wanted to rely the.
And you have given it to Mr. Banerjee, he relied upon that.
Yes.
What is the Constantly? Oh, it was not enough. Your matter order has not been passed.
No.
I can give my matters where Digambar has been distinguished, where Mr. Talukdar has relied on Digambar.
Thereafter, I think in that Mr. Banerjee's matter, I have exhaustively
Yes.
Digambar.
Yes.
Was the facts why it was
Absolutely. Well, that matter should be. Are down na.
Oh, he was not there. He handed over the book to Mr. Banerjee.
Well, I'll ring up Mr. Banerjee. I'll pass on the
Passing
information.
it over.
এটা আপাতত একটু আমার কাছে
Mr.
থাক।
Dhar, please take it.
Yes.
Or I will keep it.
No,
The report of the Special Land Acquisition Officer dated Yes.
Item 195, my lord, was mentioned today, my lord, so please to.
Yes.
This matter on the last day could not be taken up because they sought time.
Yes, where is the other side?
They are there.
My lord, Mr. Partho Pratim Roy is leading,
I'm online.
Yes,
but I am only for the respondent number 3, my lord. Only for the respondent.
The other is the state respondent, my lord, the Thika controller, my lord. They did not appear on the last occasion. Also, we've served them. Concerned respondent is respondent number 3. There is also CAN 1 filed by the licensee to be implemented party in this proceeding. My lord, the proceedings before Thika have been initiated by the petroleum company.
who is for the applicant in that can?
CAN 1, my lord, Mr. Tonma. There.
Where is Mr. Mitro?
But on his ground, the matter was fixed today. The last order would show that.
Where is Mr. Mitro?
Before my lord takes up the matter, I'm raising the.
Where is Mr. Tanmay Mukherjee?
Oh, Mr. Mukherjee is
I'm
there.
here, madam, online. Yes.
My lord, the short point here is, my lord, the pure legal question.
Starts. I am taking the maintainability of this writ application.
Yes, I will answer. I will answer maintainability first. My lord, this is against this writ assails the wrongful assumption of jurisdiction by the Thika controller to determine whether there is a Thika tenancy or not in respect of premises in question where the suit or the civil court has already held that there is no Thika tenancy, and the decree first appeal has also failed. So it's a tenancy prior to 2001. It's a tenancy created by a registered lease deed, which expired on efflux of time in 2000. I'm sorry, which expired by efflux of time in 1999. Civil suit filed. Civil suit decree of eviction passed in my favor. First appeal dismissed. Now, my lord, proceedings are sought to be instituted before the Thika controller under the 2001 Act, which, my lord, I say is a wrongful assumption of jurisdiction. So I challenge
applied before the Thika control.
one of the petroleum company IOCL, who was the defendant tenant in the eviction and who has suffered an eviction decree.
IOCL is represented by whom?
Respondent number 3 is
I am representing the IOCL.
You are appearing for IOCL.
Yes.
Now, my lord, I am on the point of maintainability, whether a writ lies under Article 226 or not, my lord, may I just trouble your lordship, my lord, where there's a pure question of law going to the jurisdiction, then I need not wait for the controller to pass any order. That is settled law, at least since.
The Tenancy Act is a specified act under the West Bengal Land Reforms and Tenancy Tribunal.
Yes.
So, Thakkar, you can approach the tribunal with.
My lord, kindly bear with me. Kindly bear with me for two authorities of the Supreme Court where self-same points were raised, alternate remedy, special statute. The court held that if there is a pure question of law, there is no disputed fact involved, and there's a question challenging the legality of assumption of jurisdiction. I say that the tribunal, the controller has no jurisdiction.
Statute means a tribunal constituted under 323B.
Yes, my lord, tax tribunals, revisional authority. May I first start with Whirlpool, my lord? Whirlpool, trademark act.
Takes the task of Whirlpool. I'm relying upon the judgment reported, unreported judgment, WP number 25183 of 2025. May I request my learned friend is.
There's a division bench judgment of our court also. I'll start with Supreme Court and end with division bench judgment of our court entertaining a 226. Against the order.
Have you gone through my judgment? I have delivered.
No, my lord, I have.
Considering all those.
Kindly give me 1 second, please, my lord.
Also, a recent decision of the Honorable Supreme Court on Administrative Tribunals Act.
226 to 27 distinction.
Because here, Mr. Thakkar, the jurisdiction of the single bench has been taken away.
My lord?
Jurisdiction of the single bench has been excluded by the statute.
But 226 jurisdiction cannot be excluded.
Section 8 of the Tribunal Act.
Kindly give me a minute, my lord.
It's only before the division bench.
My lord, kindly, I'm just going through your lordship's judgment. Your lordship has, my lord. Here, your lordship was concerned with the Land Reforms and Tenancy Tribunal Act.
Yes. Here also it's the West Bengal Land Reforms and Tenancy Tribunal Act.
Yes.
Same thing.
Yes.
And it's a
So your
specified
lordship is
act.
saying it has to be a WPLRT under 227 or whatever.
26 or
227. Kindly give me half a minute, please.
No, WPLRT is a different thing altogether. Here, land reform sector tenancy.
Land Reforms Act kholo. Land Reforms Act kholo.
Land reform sector.
Aware of this decision of your lordship?
You can consider
a fairly
this and
recent
Mr.
judgment.
Thakkar, you can come back because I'm telling you, you are aware of the L. Chandrakumar's
Yes,
judgment.
yes, your lordship has.
Now the here is the case. Now initially these matters were dealt with by the High Court under 226 single bench. Thereafter intra-court appeal before the division bench. Now the Tribunal Act has come, so as the Administrative Tribunals Act also.
Yes.
So L. Chandrakumar was on Administrative Tribunals Act.
Yes.
Now I think section 25 or 26, it took away the jurisdiction power of the High Court under Article 226. Now that was challenged. In L. Chandrakumar, it was held, no, the power of the High Court under Article 226 and 227 cannot be taken away. That was read down by holding that, yes, the tribunal will be the court of the first instance. Against that, judicial review under Article 226 and 227 will lie before the division bench.
Right.
Because Administrative Tribunals Act do not say that it's before the division bench.
I followed, my lord, here the facts are slightly different. I am not coming up from an order of the tribunal. That can be an alternative remedy. Well, kindly see alternative remedy.
6. Please kindly come to section 6 of the Tribunals Act. Land Reforms and Tenancy Tribunal Act.
Kindly give me half. Land Reform Act, not this act.
D, 6D. Matters under any provision of a specified act, then says or matters relating to constitution, this disjunctive. So any matters falling within the specified act.
Subject to the provisions of this act, the tribunal shall by exercise jurisdiction, power and authority in relation to an order in original made by an authority.
You can come straight away to D.
Adjudication of disputes and applications relating to matters under...
No. D.
6D, my lord. West Bengal Land Reforms and Tenancy Tribunal Act 1997.
Applications relating to matters under any provision of a specified act. D for Delhi.
My
6D.
Adjudication of disputes and applications. Adjudication of disputes has been removed.
So, yes, now it has been removed by this. This is, I think, there's an amendment.
So, my lord, applications relating to matters.
Yes.
Applications relating to matters under any provision of a specified act, that is the Thika Act, involving interpretation of any provision.
All matters involving. So, it's disjunctive. So, all matters of the specified act falls within that.
Yes, my lord, but this is the appellate jurisdiction. The tribunal.
Appellate jurisdiction is a different. It does not say appellate jurisdiction. Any matters.
I follow, my lord, but this is the general act.
In this, I have considered.
May I just read this and come back?
Appellate order,
may I come back?
Interim order, final order, everything I have considered. You can consider this and come back.
30th,
30th. Because I have considered.
Yes, your lordship has passed a detailed judgment taking into account
L. Chandrakumar, Ashish Rai, and there is also a recent decision of the Honorable Supreme Court on Administrative Tribunals Act also.
Paragraph 43, if your lordship kindly sees, of this judgment.
Yes.
Your lordships have perhaps, my lord, been persuaded to hold that there is an alternative remedy. That is, my lord, perhaps the ratio, but I'll go through the entire judgment. That your lordships are well, that there is
there's an alternative remedy.
And which ousts.
Excludes this.
Excludes. Now, my lord. Alternative remedy, I'll go through the facts of this case. I don't want to hold up your lordship.
Because I've also considered PHR invent also, which takes into account that under certain circumstances, even there is an alternative remedy, writ is maintainable. Yes. After that, it has been held no. In these cases, don't entertain.
I am armed with a 2023 Supreme Court. I'll check up.
PHR invent, I think, is 2024.
24.
It carves out, it considers those well-known exceptions, recognizes that. Next paragraph says no, in this case, don't entertain.
May,
So,
may I come back
and
after?
I have
I'm
also
sorry, my lord,
said-
I was not aware of this. This is
I have,
fairly recent. With this missed our attention, my lord. I'm very sorry. my
also
lord.
have considered the tribunal, it's an efficacious remedy, that is also I have considered that. Those provisions of this tribunal,
Yes, my lord, but efficacious remedy will not oust 226. Now, in the facts of
in view of L. Chandrakuma, it says tribunal is the court of first instance.
First
You have to go there.
But then
after that, you can come here.
that is, my lord, in a
Because
division
otherwise,
bench,
Mr. Thakkar,
assailing the order of tribunal, my lord.
otherwise, the whole purpose of enacting the statute will go. All purpose will go.
My lord, but the purpose is also speedy disposal and adjudication.
Yes.
Where, my lord, in the facts of a
Now
case
you
where
say
the
that there is not speedy, Mr. Tribunal, then it is to be stabbed.
Object of formation of tribunal, my lord.
Then it is to be scrapped. I appreciate what you are
That
saying.
is-
If that is accepted,
And your lordship
then no matters will go there.
But, my lord, kindly also appreciate in a fact where there is a decree of a civil court. Your lordships have held a division bench decision authored by your lordship along with Justice Sivagnanam. Your lordships have held before 2001. The rent controller, I'm sorry, the Thika controller did not have jurisdiction to adjudicate on Thika tenancy. And if there's a finding of a civil court before that, then that finding is staring at his face. It's a wrongful assumption of jurisdiction, my lord.
I appreciate that. So those are that is one of the exceptions carved out for entertaining a writ petition.
A writ.
But please see PHR invent also.
My lord, kindly keep it day after, my lord.
I think next
30th, my lord, I have
Mr.
some
Rai,
difficulties, my lord.
what will happen?
Mr.
Same
Rai,
thing will happen.
Very well. Then fifth.
Fifth or sixth, any day, my lord, I have no problem.
Sixth, my lord, sixth, I've got this other matter which
will
is
be the better.
today, my lord, all hearing matters are taking place smoothly, my lord. Fifth, please, my lord.
Mr. Rai, where is that Supreme Court decision on administrative tribunal which I have considered?
Just I do have the copies, they are coming with me. Because today, my lord, yesterday night, my lord, I received the call and today things better than this. I only have the copy. My asked my learned junior who is appearing, my lord, hand over a copy from where it was recorded. It was recorded. Precisely my argument was
West Bengal was Ashish Rai. Is that what
No,
you're
no, 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 no.
No. It's from Karnataka, I think.
Karnataka High Court.
Yes, paragraph 17, perhaps.
Leelavati was the state of Karnataka.
Paragraph 17 of your lordship's judgment. my lord.
2025.
Yes.
Leelavati.
Leelavati, that's 2025. And 2024 is PHR invent.
She carves out Bharisha principle natural justice in spite of my lord is of the
Yes,
opinion.
I've quoted that. PHR invent, if you come to paragraph 18 of that judgment, I've quoted this paragraph 35 and 37. Then in 38, it says, if an effective alternative remedy is available to an aggrieved party or a statute under which the action complained of has taken itself contains a mechanism for redressal of grievance, then 226 should not be entertained. High Court will not entertain the petition. That's the language used. After recognizing the well-known exceptions in paragraph 37.
My lord, I think I am in a bit of a sticky spot, my lord. May I not open my mouth any further? May I come back on fifth?
Because that was a point, and that was also a question of jurisdiction in this matter. What happened, a section 5 application was allowed by the appellate authority without even serving a notice upon the other side. That also was a question of jurisdiction.
Violation of principle natural justice.
Yes, so question of jurisdiction as well as violation of the principles of natural justice, it was allowed without even serving notice upon them. So it's a jurisdictional error or principles of natural justice on both counts. Alternative remedy is not an express bar.
Lord, I don't know what is the bench strength of these judgments and whether they've considered the previous judgments, but I'll try to satisfy your lordship. My lord, this is curtailing the power of the High Court, my lord, is not. My lord, we have to be alive to the ground reality,
It's
my lord.
not carteling, I'm telling you. It's not carteling because it's L. Chandrakumar says that. It says tribunal will be, now the scheme has changed. These matters were previously being dealt with by the single bench of the Calcutta, of the High Court. Now, after, with the coming into force of this 323A and 320DB, those tribunals, those have been made the court of first instance. So the single bench power that has been taken away, substituted, should not be said substituted,
cannot be.
supplemented. So it's a supplemented by the tribunal from that division bench.
It's like an
So
appeal
not
from
taking
the.
away. So
It's like a first
initial
appeal is the
scrutiny-
tribunal. First appeal before the tribunal, further appeal
Yes,
before the division.
so initial on facts tribunal will decide. That is why they have used the expression court of first instance.
That's what I said, man. Court of first instance.
Yes, so you have to go there. Thereafter, from the division bench, not taking away not curtailing the power, because that was the argument in L. Chandra Kumar, that it takes away. And in Administrative Tribunal Act, you will not be finding that division bench jurisdiction was preserved. Now this Land Reforms and Tenancy Tribunal has been enacted 6-7 months after the passing of L. Chandra Kumar. It takes care of that. It preserves the right of the division bench, excludes the right of the single power of the single bench under 226. I have considered those aspects when it was taken.
In this judgment, your lordship has considered.
Yes.
The fairly
So-
exhaustive judgment.
And Leelavati also considers that that was on tribunal.
Mr. Roy cannot
Yeah.
lose both times.
Yes, that is that argument I can make. I can
Yes, argument, because
I follow.
He appeared in that matter. He was trying to persuade that to take up, because that was also a question of jurisdiction. Now he will be saying, I cannot lose.
I hope he's assailed this, my lord, for us, my lord, on this who practice in the High Court. Assailed. Whatever it was, my lord, I don't know.
No, I would be.
I tell your lordship, my lord, tribunals are a disaster. My lord. Your lordships.
That was the argument which I
Lordships, not all tribunals are a disaster.
today. That was the
Are a
issue.
disaster.
I don't care
Across the
about.
board.
But Mr. Thakkar, we cannot say that.
Now the now your lordships are saying we should bring back the tribunals. Now your lordships are saying.
Till that is not.
Till yes. I know. I have to, my lord, find a way, my lord. Kindly keep it on 5th, please, my lord. My lord, as a my lord, your lordships keep it and because today it was supposed to appear in the motion. No motion here.
Mr. Thakkar, 5th, I'm keeping it on 6. 6th, you have a problem.
Well,
Because 5th, I will be only having one half. Because second half will be cooperative societies.
6th, then in the second half, please, my lord. Because this matter which I was arguing, my lord, I got late in coming here. That was also being kept on 6th. 6th, second half.
Let it appear. If you are in difficulty, I will be taking.
No,
up.
my lord, your lordship has a very heavy board, my lord. I cannot take that risk. Your lordship takes up.
Then
I don't think.
No problem.
If I can.
Mr. Thakkar, it is for the.
How are you placed? 4th will not be.
4th is a bit risky. 4th, I don't think anybody will come.
4th will be also a good day for hearing this.
Good day for these.
If Mr. Thakkar will take care of it, he will argue on 4th and he'll come back later.
Sorry.
Ask me. Kindly, I'll just pray for an accommodation if I'm not there.
Yes, yes.
I advise this, Malad. Now it's my responsibility to make any. But they came to me for advice. I said I was not aware of this judgment. It is come after this judgment. Let me consider this.
Mr. Thakkar, learned senior advocate, commences his argument.
অনেক judgment
My lord, this petitioner was sixth or fifth.
sixth বলবো। Sixth actually. Grateful, deeply. May the affidavit of service be kept. May the affidavit of
service taken on record.
Grateful, my lord. Deeply obliged, my lord. এই, এটা তো জজ সাহেবের ভুল।
Delayed by 1 minute, Mr.
No, I was here, my lord.
I was
No,
delayed.
no, I'm sorry, ma'am.
Yes.
Well, sometimes it is profitable to be in the courtroom, to understand what is happening in the courtroom. Well, I learned that your lordship had delivered a judgment which is yet to be reported, governing the issue which I am trying to canvass before your lordship. I was sitting here, well, we are getting the copy right now. But before I take your lordship to your lordship's judgment,
Refer to that.
obviously I will refer to your lordship's judgment. Obviously, it goes without saying. It is, my lord, I've got the neutral citation. There is a
Have a copy of that. No.
We are getting it right now. We are getting.
নাহলে ওইটা কপিটা বার করে নিন।
Well, I will be referring to your lordship's judgment because your lordship has considered the scheme of the Tenancy Tribunal Act,
সাক্ষারের যেটা হলো না,
LRTT Act. Your lordship has considered the scheme. Your lordship has considered the law laid down by the Constitution Bench in L. Chandra Kumar. Your lordship has also considered Ashish Kumar Roy. Your lordship has considered the judgment in the case of Karnataka, Lilavati, and also PHR Invent, which is a 2024 judgment rendered by the Honorable Supreme Court. So, my lord, I will just give your lordship the relevant paragraphs. But
The only thing, Mr. Mojumdar, that is on an issue, if there's an alternative remedy.
My lord, I will.
The,
My lord, yes.
What Mr. Basu's argument is that
Yes.
it does not fall within the four corners of
I
the
will demonstrate.
1990
I will demonstrate.
So that is why
That
he
is
said,
why, my lord, it is necessary I take your lordship to the pleadings in the writ petition.
Yes.
My lord, kindly take the writ petition for once.
Yes.
If your lordship kindly takes, my lord, paragraph 21 of the writ petition. May I give your lordship the brief synopsis? First, my lord, what are the relevant facts for examining the issue of maintainability? Only the relevant facts I'm placing. But the state government on July, your lordship will find at page 6 of the first supplementary affidavit. Kindly take, my lord. Yes, my lord. Their supplementary affidavit, first supplementary affidavit, page 6. Only the relevant facts I will place.
Supplementary.
From the 19th January.
19. There are two supplementary affidavits subject to correction.
Not
The
March.
answer is on 19th January. That is the second one.
March is the new one. There is an affidavit affirmed on in the month.
19th of January 2026.
Yes, my lord.
Yes.
Kindly take, my lord, straight away come to page 6.
Yes.
This was placed
Yes,
over
this
and
was
over.
heavily relied upon.
Heavily relied on. But so, my lord, this is the sanction accorded by, my lord, the Land and Land Reforms Department to the long-term settlement of 17.1065 acres of land at Mousa Garden Beach, jail number so and so, so and so, so and so, for the purpose of setting up our township and school. Now, my lord, kindly take the first paragraph only. The undersigned is directed to refer to the above subject and to say that the governor is hereby pleased to accord sanction to the proposal for long-term settlement of 17.1065 acres of land under section 4B2 of the WBLR Act and detailed in schedule below in favor of Fab Leathers Limited for a period of 99 years with effect from the date of issuance of this letter. My lord, the annual rent is fixed, and also, my lord, the premium, subject to the condition that the existing school lying within the premises should be rehabilitated in equal area within the project area. So, my lord, this is, my lord, the sanction which is sought to be challenged. Kindly take the page straight away, page 9 of that affidavit only.
Yes.
Kindly take, my lord, the recital clause. The first one, page 9 itself. This indenture of lease made under subsection 2 of section 4B of the WBLR Act this day between the governor of state of West Bengal, hereinafter called the lessor of the one part, and then Fab Leathers.
So, now kindly take the next page. Whereas the lessee has applied before the state government in the Land and Land Reforms and Refugee Relief and Rehabilitation Department to retain 17.1065 acres of land comprised in erstwhile means of factory workshop under section 61G and subject to section 63 of the West Bengal Estate Acquisition Act for the purpose of township and school activities mentioned in section 14Y of the WBLR Act, excluding tea garden. Similarly, Lordship will find this lease has been executed in favor of these fab leathers or the answering respondent before Lordship in excess of the power conferred under section 4B of the WBLR Act, read in conjunction with section 6.1 and 6.3 of the WBE Act. Now, having regard to this particular memos and the lease, kindly take, my lord, the petition. Kindly take paragraph 21 of the petition. Read petition straight away. Section 4B of the WBLR Act permits long-term leases for industrial or infrastructural purposes subject to public interest. I am sorry, my lord, it is page 14 of the writ petition.
Yes.
Para 21.
Yes.
Section 4B2 of the WBLR Act permits long-term leases for industrial or infrastructural purposes subject to public interest. That statutory power, being extraordinary, must be exercised in a manner consistent with public interest, welfare, and procedural fairness. Where a specific educational institution's claim has earlier been recognized, my lord has got that, I'm sorry.
Yes, yes.
Recognized and processed by the state, the absence of interdepartmental coordination, absence of notice, and failure to preserve the public purpose the fundamental need for minority education renders the sanction legally questionable. Kindly mark the word minorities. It is very important.
Yes.
Renders the sanction legally questionable as procedurally vitiated and legally and fundamentally and administratively untenable. In the interest of administrative equity and public good, it is imperative that at least 1 acre from the total of 17.1065 acres be carved out and reserved for petitioner to satisfy the essential requirement for a playground and safe access for the petitioner student egress and ingress from the to and from the school in its rear side through the vacant ground to the old dilapidated gate of jute mill to Dr. Abdul Khabir or Kadir, I don't know, road opposite to Nadial. So, this is the challenge as to the exercise of the power under section 4B of WBLR Act, which according to them has not been exercised properly, and this statutory power has been exercised in an arbitrary manner. That is the sum and substance. Kindly take paragraph 23.
Yes.
Pursuant to the continuing culpable administrative inaction in furtherance of the petitioner's right, a formal demand for justice for urgent administrative review was served upon the concerned respondents on 14th November 2025. The petitioner, through the said demand notice requested for an immediate administrative review and inquiry into the purported sanction or lease granted under section 4B2 of the WBLR Act, insofar as it affects DAG number 134. The petitioner also sought reservation and settlement of at least 1 acre for the petitioner in continuation of the proposal already processed logically and in due course of law and promises since 2017 and an immediate direction to restrain the lessee developer and their agents from undertaking in development, encroachment or alteration over the demarcated area pending such review. So again, my lord, the action taken or the steps taken under section 4B2 is questioned. Now, my lord, kindly take ground number 10.
Yes.
Your lordship will find, again, my lord, reference to 4B. Down ground number 13. They are challenging the lease granted under section 4B2. Now, my lord, it is their case. If I have correctly understood. Konta? 23 দেখালাম তো না ground number 23, I'm sorry, 23, direct challenge. Your lordship will find that. So, Malad, whatever bundle, and if we perceive of their case as a bundle of claims, let us perceive their case as a bundle of claims. The bundle of claims, the fulcrum in the bundle of claims is, my lord, the exercise of power under section 4B2 of the WBLR Act. It is, my lord, like the main pillar or the foundation with respect to their claim. My lord, my learned friend used the expression, or my lord, relied on the doctrine of legitimate expectation.
No, legitimate expectation, I've
Yeah.
stopped him from making that submission.
Yeah, my
because
learned friend has also made submissions
don't,
regarding.
argue on that
I'm
because
not
I've
arguing.
not.
My lord, only one thing, my learned friend has relied on the fact that the school is a minority institution, if I have correctly understood my learned friend. Your lordship will find there are several paragraphs in the writ petition which says that the school is a minority institution, and therefore it is entitled to protection under Article 30, Clause 1A. My lord, kindly take one document. Kindly take, my lord, their second supplementary affidavit. My lord has got that?
31st of March.
Right, my lord.
Yes.
Yes, my lord. Kindly take page 14. Well, this is their application in the prescribed form for upgradation from class 10 to class 12.
14.
Page 14.
Yes. Yes.
My lord, kindly take, my lord, serial number 4. Does the Trust Foundation Society belong to a religious body or a minority community? If so, give details. Not applicable. It is their case before the state government that this is not a minority institution. This is, my lord, in my most respectful submission, the averments made in the writ petition are contrary to the records. Well, I'm putting this in a very mild manner, because this is what is on record. Well, this is not our record, this is their record. Then, my lord, kindly take, my lord, there another case was that since they are not getting that land, additional land of 1 acre, they were not upgraded. That was their case initially in the writ petition. Even, in fact, my learned friend, while making submissions yesterday, has emphasized that the upgradation is not possible because of for want of land. In the second supplementary affidavit, they say that whatever they have stated in the writ petition, that the school has not been upgraded to 11-12, I mean the higher secondary level, that is an incorrect statement made by mistake. On the basis of this application made at page 14, the school had been provisionally upgraded to 11-12. Your lordship.
Provisionally, but subject to that playground.
No. Kindly take the provisional upgradation later. Kindly take the provisional upgradation later. It is not so. Kindly take first Form 1. There is no requirement in Form 1 that they ought to have a playground. There is no clause for that. Kindly take now, my lord, page 24. May I just read out? Page 24 is the provisional upgradation which was issued in favor of the petitioner school on February 17, 2020.
Yes.
May I read it out? I am directed by the President Council to state, this is from the Deputy Secretary, WBCHS. I am directed by the President Council to state that your institution has been accorded provisional recognition for introduction of higher secondary general stream courses with effect from 2021 session for 2 years on the following conditions. The institution will not introduce any subject without prior permission of the council, and the institution will not be allowed initially to introduce any subject for which they have no duly qualified teacher on payroll. Number 2 condition. That the institution will allow the council to use its building furniture for examination and other academic purposes as and when necessary, and the institution will fully cooperate with the council in respect of the above matters in all possible ways. That the institution will collect relevant regulations and circulars regarding admission, migration, registration, examination, etc. and Samsad Porichiti from the council. That the institution will abide by the rules, regulations, and provisions of the circulars from the council from time to time. That the institution will remain enrollment prescribed by the council, maximum 275 students and minimum 35 students for government-aided institution, maximum 500 students at minimum 75 students for self-financed institution in a year, and will not admit students in excess of the prescribed limit. The provisional, kindly take my lord, will not hold higher secondary classes kindly in the morning, evening, kindly take clause 7. That the provisional recognition accorded to the institution may be cancelled, withdrawn, and kept in abeyance if the institution fails to fulfill the above conditions as well as other conditions prescribed from time to time. It does not say either expressly or by necessary implication that unless and until you get the playground or the area, the land for playground, your provisional recognition would be cancelled. I believe, subject to correction by my learned friend, the provisional recognition or approval has been continued, has been extended from time to time or renewed from time to time. Kindly take, my lord, the recognitions, the extensions. 27 is the first extension, that is dated 30th January 2023 till June, and 28 29 is the another extension till June 20 till June 30, 2026. So there is no, my lord, there is no whisper even in the letter according, my lord, provisional recognition that unless and until you secure or get the land for playground, your provisional recognition would be cancelled or quashed or withdrawn. Two very important facts. My lord, the halo of minority status is not there. They're without that halo. Second is that their case in the writ petition was it's a class 10 school. Specific averment was made. Then in the second, kindly take, my lord, their averment in the writ petition. Yeah, paragraph 1. Of the writ petition at page 5.
5 to 10.
Yes. Then, my lord, read it along with subject to lordship's kind consideration. 1. Kindly take along with that paragraph 10. When this paragraph 10 was read out by my learned friend yesterday during the course of his submissions.
Yes.
Then, my lord, kindly now take their supplementary affidavit, second supplementary affidavit, which is, my lord, para 5, 4, 5.
Second supplementary affidavit.
Yes, ma'am, that was affirmed sometime in the month of March, subject to correction.
Paragraph?
Paragraph 4, your lordship may kindly take. Yes. I state that during the course of hearing of the instant writ petition, it has come to the notice of writ petitioners that in opening line of the writ petition, the petition number 1 has been inadvertently described as a government-aided school having classes 5 to 10. The said bona fide description is due to a typographical error, inasmuch as the expression is sought to have been was. It is clarified or that the petition number 1 was originally a school having classes 5
They have said that it has been upgraded.
Upgraded. But there is no document, there is no suggestion from the school education department that their provisional recognition for higher secondary classes or higher secondary level would stand terminated, withdrawn, or cancelled for the want of land for playground. There is no communication. Now, my lord, now these are the facts. And my lord, the high minority status, I think I have made myself clear. Their document shows that. Now, my lord, kindly along with this, kindly take, my lord, now kindly take L. Chandrakumar for once. My lord, I have gone through your lordship's judgment. It summarizes everything. এনেছিস কপিটা? না জজ সাহেবের জাজমেন্টটা কোথায়? তা দে ওটা দে। This is your lordship's judgment. হ্যাঁ 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 দে কপিটা দে। But nowadays, Malal, we have the neutral citation. Your lordship will find there is on the right hand top there is a neutral citation.
Yes.
So, Malal, now if you
Only one thing, Mr. Majumdar, before going to this judgment, because Mr. Basu's specific submission was that it does not fall within the scope of
yes, my lord,
19
I want to show that. Kindly take, my lord. That is why
because
first, my lord, kindly take the act.
he is not challenging any decision.
Oh, my lord, kindly take the prayers. This is a fantastic.
Challenging
My,
any
that is a fantastic submission.
authority. So because
I'm so sorry. I should have read the prayers. I'm so sorry. It is my bad. Kindly take the prayers.
so that was Mr. Basu's submission.
Malad, I should have answered to that. I should have answered to that. Kindly take the prayers. We start at paragraph 20, page 26. But I've already placed the paragraphs, averments, and grounds. Kindly take the prayers. First prayer itself is indicative. What is the scope of challenge? Issue a writ of mandamus directing the concerned respondent authorities, particularly 1, 5, 6, and 7, each one of them, to reserve, demarcate, and settle 1 acre of land out of Dag number 134, jail number 31, Moza Garden Reach, in favor of petitioner school for playground, educational expansion. There is no scope for expansion, already expanded. And safe ingress and egress in logical continuation of the departmental processes and recommendations of the respondent, number 2, 3, 4, and 8. Kindly take along with this, my lord, paragraph 23 of the writ petition.
Yes.
Kindly take, my lord, the second sentence of paragraph 23. The prayer A is basically aligned with, my lord, the second sentence of paragraph 23, which says also sought reservation and settlement of at least 1 acre.
Paragraph 23.
Yes, my lord, at page 16. The second sentence, third sentence.
For reservation, yes.
That is the exact prayer made in prayer A. Administrative.
No, Mr. Basu's submission is that I've made a representation.
Yes.
No, he says, if there's a decision on the representation,
right,
and if he wants to challenge that decision,
right,
then the tribunal may have been a remedy.
Well, then,
but he says,
yes,
that I've made a representation, but no decision.
Since there is no order, I cannot
no order.
I cannot go to the tribunal.
Yes,
I understand.
according to him,
Mr. Basu read out, my lord, clauses A, B, C, but there are other clauses under section 6 of the Tribunal Act. My lord, particularly, my lord, kindly take the other prayers, then I will take your lordship directly to that portion. Kindly take the prayers. Prayer C and D.
But nowhere I think any order has been challenged.
No.
Nowhere.
No, my lord, they have challenged the decision taken by the government to grant lease under section 4B2 of the Act. And that is why grounds are, paragraphs are 21, 23.
Prayer does not say that.
Prayer says, my D is clear.
Entire process of sanction and
then it is all there. And my lord, as I
according to you, this is not a direct challenge of
direct challenge. Yes, direct challenge. Now, my lord, I take your lordship to this LR Act, LRTT Act. And pass consequential act, take consequential action. That means, my lord, termination of lease or whatever it may be. Kindly take, my lord. Clarify. Kindly take, my lord, the LRTT Act for once.
Yes.
Kindly take, my lord, section 6. Mr. Basu read out, if I am not wrong, clauses A, B, and C.
You will be on D first limb.
Straight away D.
D,
D is a kind of catch-all provision. Cure-all, catch-all.
And or makes it disjunctive the next
yes,
part.
yes. Well, it is like, my lord, what your lordships have in the residuary jurisdiction. Whatever is there, everything is there. My lord, there is a saying that when there is a provision, when there is some kind of item which cannot have its parentage, it should be sent to orphanage. Orphanage
Takes
or the
care of everything.
it takes away. So it is embracing everything in itself. So the D takes care of my cases, my case. Now, my lord, along with this, my lord, my respectful submission before your lordship would be that, as your lordship had explained in Gauchandra Ghosh, they Judge সাহেবকে দিয়েছিস তো?
Have you given a copy to Mr.
Yes, we have given. আমি আসছি। মানে may I just take your lordship to L. Chandra Kumar for once? Then I take your lordship to Gauchandra Ghosh.
92, 93, 97, 98.
My lord, I will start from 80, 81.
80.
Yes, 80. Kindly take, my lord, 80. My lord, I will not waste your lordship. 78 your lordship has considered your lordship's judgment. Kindly take 81. Yes, L. Chandra Kumar. Your lordship has considered 78. 80 if your lordship kindly take placitum E.
Yes.
So long as the jurisdiction of the high courts under article
Placitum here.
placitum E.
There is
Oh, I'm sorry, my lord. এটা কি দিয়েছিস? 81 বলছি রে, 81.
Why SCC volume there is no placitum? Why?
My lord, this is not the true print. This is the normal print.
That is why placitum goes.
Placitum goes. I will take your lordship.
All right, paragraph
No, my lord, I'll take your lordship. Kindly take, my lord, internal page 60. What is this page? 55. Page your lordship will find on the left
Page
hand.
54, page
55.
Yes, page 55.
Yes, my lord. Kindly take, my lord. So long, the third line from the top, fourth line from the top.
Yes.
So long as the jurisdiction of the high courts under 226 or 227 and that of this court under 32 is retained, there is no reason why the power to test the validity of legislations against the provisions of Constitution cannot be conferred upon administrative tribunals created under the Act or upon tribunals created under Article 323B of the Constitution. This is 81. Then, my lord, 9091, just once. My lord, just for the, my lord, I am just giving the points. Your lordship may kindly consider these paragraphs. 9091 only for the purpose. Power of judicial review under Article 32 or 226 cannot be excluded. Then, my lord, in my language, tribunal decisions involving constitutional issue would be subject to the jurisdiction of high courts under 226 and 227 of the Constitution. Your lordship will find. এটা আমার ভাষায় বলছি, এটা 1991 দুটোতেই আছে, হ্যাঁ, ঠিক আছে। Now, my lord, now then 92, no direct appeal to Supreme Court. You take the route of division bench of the High Court. Then 93 onwards, your lordship has dealt with that. 93, 99, 94, your lordship has dealt with that in your lordship judgment. I need not bother your lordship with that. My submission before your lordship would be that, well, it is something more than an alternative remedy. My submission is that this constitution bench in L. Chandra Kumar, subject to lordship's kind consideration, I may stand corrected. My lord, in L. Chandra Kumar, said that held that the tribunals will play a supplemental role. In my respectful submission, to the best of my understanding, it is like creation of a multifora constitutional remedies. The first forum being, my lord, the tribunal, and the second forum being the High Court in division bench. It's a multifora constitutional remedy. So, my lord, it is something more than statutory remedy.
Why the tribunal has been said to be a court of first instance.
Court of first instance. And your lordship will
cannot
find
be a substitute.
Yes,
but in a way it's substitute.
It's very interesting, my lord, this in a way substitute.
Because Justice Datta in one of his lordship's judgment has said it's a substitute of the single bench.
My lord, it may not be so, subject to correction, my lord. It's a kind of, my lord, what should I say? Allocation of business.
Yes.
It's an allocation of judicial business.
Because
For,
to
my
take
lord,
away
for
the workload of the High Court.
Yes, my lord, to streamline the process of, my lord, justice dispensation system, it is streamlining the system. So, my lord, now your lordship will find some very interesting thing. The L. Chandra Kumar judgment was delivered in the month of March 1997.
After 6 months, this act was.
And, my lord, this after
considered that.
Yes, your lordship will find in the preamble, in section 7, in section 8, It is specifically provided that
L. Chandra Kumar considered the Administrative Tribunals Act,
yes,
which did not preserve the power of the High Court under
right,
26 to 26.
because madam, that part was held to be unconstitutional.
Then it was said it has to be read down.
Yes.
So it will be only the High Court
Absolutely, absolutely. Madam, I cannot.
the power
Absolutely, absolutely. That's
that
the
has been taken care of in section 7 and 8.
Section 7. And that you have the right. So, my lord, now it is not that the petitioner is left without remedy or cannot get any action of the administrative authority under the specified acts to be examined under the power of judicial review, but it will be at a later stage. First, the tribunal will examine. Then, if they are so aggrieved, it may so happen that a tribunal may be the effective remedy. They may get the relief from tribunal. They need not come to the High Court. So, whoever is aggrieved in those cases, they will come to the High Court and invoke Article 226 or 227 as the case may be, so that the High Court can exercise its power of judicial review, which is ingrained in the basic structure of the Constitution. That's the whole idea which I could gather. That is my humble understanding of the position of law. Now, I will quickly rely on your lordship's judgment.
You have given a copy to Mr. Basu.
Yes, I have. Yes, so I'm making my position clear. In my understanding, it is not merely a statutory remedy, because it is created under the Constitution. Unlike we take industrial tribunal, we take some.
It's not like other statutes giving some remedy.
Yes.
It's under 323A and 323B. It's a machinery.
Under that. So, my lord, the statute basically prescribes the machinery for administration. But, my lord, whatever
and if it is efficacious,
yes,
then you have to go there.
Then have to go there. And, my lord, despite there being argument made before the Honorable Supreme Court that it is not efficacious, tribunals are not working, the Constitution bench of the Honorable Supreme Court.
Now it has not been scrapped.
You know, it has been scrapped. And Sampath Kumar still remains pending. I learned from when the lordship might be at that time, your lordship was sitting with the Honorable Chief Justice Sivagnanam. Both Chandra Kumar and Sampath Kumar were his colleagues in Madras. They belong to the same chamber. If your lordship may remember those days. So, my lord, so we know that how this law evolved. The law evolved in this way. And Sampath Kumar is yet to be decided. And I think, my lord, unless the tribunals are scrapped, your lordship will find in Odisha, my lord, the administrative tribunal has been scrapped. There was a challenge to the Supreme Court, but it failed. Scrapped is scrapped. And, my lord, not only that, take the section, if your lordship can take section 9 of the Act, all the pending cases have to be transferred. So, my lord, it is kind of, my lord, what should I say, my lord, if I am allowed to make that submission, it is like, my lord, outsourcing through a constitutional process. It is outsourcing through a constitutional process.
Basically, to take away the workload
of the High Court. Workload of the
initially you can go there because on facts, because judicial review, you know, the scope is very limited.
Very limited. Very
if it is at the first instance, the scope will be wide.
Yes, my lord, because they can be the last fact-finding authority.
Because that's the tribunal.
That's the tribunal. Because they have trappings of the civil code, but they are not obviously the civil code. Yes. There are trappings of the civil code. So, my lord, now I take your lordship to straight away to the judgment rendered by your lordship straight away. Instead of wasting your lordship's time, or I told your lordship I would be economical. I am running late, in fact. 5 minutes I have crossed. So, kindly give me 1 minute. I will just take your lordship to the relevant paragraphs of your lordship's judgment. Then I will conclude. Yes, Gaurchandra Ghosh. Well, it is yet to be reported. I don't know why it is not reported. L. Chandra Kumar, your lordship had considered at not yet reported. But it has the neutral citation, paragraph 14. Then, my lord, Ashish Kumar Rai, where, my lord, the validity of this act was questioned. That is at paragraph 16. Then, my lord, your lordship has dealt with the Karnataka case. That is Lilavati versus State of Karnataka, Radhakrishnan Industries. So, my lord, that is at paragraph 17. Then your lordship has dealt with, my lord, Anand Kole, the division bench judgment of our High Court, at paragraph 22. Then your
HR invent also.
HR invent PH.
Yes,
Yes. Your lordship has also dealt with, my lord, the scheme of the act, which is most important in this case. From paragraph 27 to 37. That is the most important part
If
of
it is not efficacious,
Yes,
then
yes. Obviously, my lord, then it has to go. Then, my lord, your lordship comes to the conclusion at paragraph 38. After going through the aforesaid provisions of the 97
paragraph
Act.
26, recapture Jain's case.
Yes.
There also an age-old judgment of 64 Supreme Court. was
Nathan Singh Nathmal, your lordship may be aware of must have dealt with Than Singh Nathmal was a typical case.
Taken note of that.
Yes, Than Singh Nathmal, I tell your lordship what happened. They filed a writ petition before the High Court against an order passed by the tribunal. They say, the Supreme Court says, why have you filed a writ petition? Make an application for reference or review or appeal before the High Court, but under that provision only. Than Singh Nathmal was considered and applied in this Chabil Das Agarwal, which your lordship has also considered. Chabil Das Agarwal also refers to Guwahati Carbon, which is, my lord, one of the leading judgments regarding alternative remedy. But it all comes down to three major judgments, I tell your lordship. One, my lord, is that obviously, my lord, K.S. Venkat Raman, that is the old Supreme Court judgment. Then, my lord, this 1999 Supreme Court Whirlpool takes care of all the cases. Followed in so many judgments, the 3 exceptions or 4 exceptions carved out. But these are all, my lord, statutory remedies. This is not a statutory. Suppose, my lord, as an illustration, I'll not take more than 2 minutes. As an illustration, suppose, my lord, a BLLRO passes an order which is not authorized to pass. It's a case of jurisdictional error. Then, my lord, an original application could be filed instead of exhausting the remedy of appeal, could be filed before the tribunal. When the tribunal is vested with the power to examine the validity of the provisions of the specified act, not the parent act, which constitutes the tribunal.
That's the distinction.
That's the distinction. Then obviously, my lord, tribunal will be in a position to examine all the issues, including natural justice, including jurisdiction, and violation of fundamental rights. As, my lord, playing a supplemental role to the High Court, so that, my lord, if the matter is carried to the High Court, this Honorable Court, or any High Court, then, my lord, the High Court will be in a position to examine, because High Court will not get into embark on an exercise or a fact-finding exercise. The High Court will ascertain the facts from the tribunal, see that what is the decision-making process, where there is an error, and whether it is subject to judicial review and what can be done under judicial review. Your lordship has summarized this. Then, my lord, kindly take 38 is the summary at the end of the judgment. Than Singh Nathmal, your lordship has considered. Then your lordship has also considered Magad Sugar, Radhakrishnan, all sales tax cases, my lord. All sales tax cases. Magad Sugar and Radhakrishnan, my lord, in both the cases, I believe Justice Chandrachud was a member of the bench. And, my lord, there is the other judgment which my learned friend has relied on, that is Godrej Sarali, which we now cite often, so that we can get rid of assessment orders and come to the writ court. But, my lord, Godrej Sarali is not a case of a tribunal. It's a case of suo motu power of review, which is akin to revision.
There's a distinction.
There is a marked distinction.
Yes, tribunal and a remedy.
Yes.
Because there's also a decision.
Yes.
Of the Honorable Supreme Court.
Yes.
While considering this alternative remedy.
Right.
The Honorable Supreme Court was considering. Now, under the Civil Procedure Code, we will be finding that certain orders have been made appellable.
Right.
The question would be, if there is an error of jurisdiction, or without jurisdiction, whether instead of going to that appellate remedy under Order 43 or other things, you can straight away come to the 227. The Honorable Supreme Court has held, yes, under other statutes, even if you can bypass that, but when remedies have been provided under the Civil Procedure Code, 227 is a near absolute total bar.
Total bar.
That's the language used by the bench presided over by Justice Nariman in that
Justice
judgment.
Malo, Justice Banerjee,
Nariman.
Justice Nariman. Wait a minute, that Malo.
So it has been said it's a near absolute total bar. That's the language used.
Because Malo, that is how Malo the
But it's a different footing. It says then against a decree you can also challenge by 227.
Right.
Two examples were also given in that judgment. But those that is under the Civil Procedure Code, there also a distinction was made that remedies, alternative
In fact,
remedies
Malo,
under
before
statutes.
Radhesham Chavinath, everything could be challenged under 226 also. Surya Dev Rai was explained in Radhesham Chavinath. Malo, this is how Malo the law stands, and your lordship has dealt with this position of law. Concluding my submissions, my lord, from the tenor of the writ petition, from the reliefs claimed in the writ petition, unless and until my lord my lease goes, he cannot step into that land. Or my lord, my lease is truncated in some way. He cannot deal with this
So
land.
in effect, according to you,
Yes.
His challenge is to the execution of the lease in your favor.
Yes. I mean, it is inextricably linked. That link cannot be broken. If the link is broken, they are otherwise out. So the appropriate remedy, in my most respectful submission, would be for the tribunal. And my lord, obviously they have their constitutional remedies. That is the constitutional remedy, supplemental constitutional remedy. And my lord, they can come to the court if they are otherwise aggrieved. Another one, my lord, we have cited one judgment of 2022 8 SCC 210. Your lordship has noted in your lordship's first order.
Yes.
Your lordship will kindly take para 54 of this judgment.
28210.
Yes, your lordship has referred to that, recorded that in your lordship's first order. My lord, kindly take paragraph 54. 2022 8 SCC. এটা প্রথম অর্ডারে রেফার হয় না আসেলা মিটার না asset reconstruction versus SP Bela.
Yes.
So my lord, now kindly take
paragraph
54. My lord, kindly take Placidum E. Oh, I'm sorry, my lord. The second last sentence.
Yes.
A challenge to the very execution of a document.
Paragraph.
Sorry, there 54. Sorry. A challenge to the very execution of a document is a challenge to its very DNA, and any defect or illegality on the execution is congenital in nature. Therefore, such a challenge by its very nature has to be made before the civil court and certainly not before the writ court. In this case, it will be before the tribunal. Because the remedy is the lease has to go. And the lease has to be redefined insofar as the schedule is concerned.
Either modified or set aside.
Or terminated, cancelled, whatever. So this is the effect of the judge. These are my most respectful submissions. But I am 15 minutes out. I'm sorry. 15 minutes out.
Yes, Mr. Vasu.
I would only, my lord, first beseech, my lord, that would your lordship kind wisdom to give me a leeway to respond to what additional submissions that Mr. Majumdar has made. Because there is something new, and my lord, it is settled, my lord, the maintainability. Whosoever raises, my lord, he has to prove it, that it is not maintainable.
Yes.
Now, my lord, at the opening submissions, my lord, Mr. Majumdar restricted to L. Chandrakumar only. So I also responded with my little ability to that. Now, if your lordship...
No, only one thing, because I stopped you from citing decisions.
Lordship.
Because your submission was that it does not fall within 1997 Act.
Extremely grateful.
So that is why I asked you not to cite any decisions on the alternative remedy. But Mr. Majumdar now says from your pleadings and
he says, my lord, sorry to
within 6D.
Exactly. Now, my lord, sorry to just pause, my lord, intervene your lordship. Maybe the catching submissions that your lordship may appreciate that he says
submissions of both of you.
My lord, I am nowhere, my lord, to him. Of course, my lord, to your lordship also. But he says that it is not that I am not left without any remedy.
No. It's not that you are left without any remedy.
No. According to him, my remedy is there.
Yes.
So, according to him, that so far as my case is concerned, I could not say that I am left without a remedy except to this court.
Yes.
I say I have only one remedy.
Yes, yes.
That is to this court.
But
This is the basic distinction.
only one submission, my lord. I'm sorry, my lord. I'm sorry. In the first order, your lordship has recorded whatever I submitted today is recorded in the first order.
That was nothing new.
It is recorded in
But
the
in
lordship
reply
first
to
order.
the law point, my lord, he has taken your lordship to the facts. I have everything.
No,
My lord, I have
had
a befitting answer even to those facts are in issues. Your lordship may decide this.
Only one thing,
My-
Mr. Basu, Mr. Bojumdar has not placed in extenso.
No,
No, absolutely.
You relied upon Article 29 and 30.
My lord.
He has produced one, shown your document from your supplementary affidavit, your declaration in one of the forms that it's not a minority is not applicable. Then he has shown some of the paragraphs to say what was your challenge.
My lord, in that case, my lord,
So that your challenge was under 4B.
my lord.
That was what he wanted to show some of the pleadings and the prayers.
Absolutely.
Then he said that your case falls under 6D and he has relied upon, for this he has relied upon this.
My lord.
Yes.
If your lordship, would your lordship would like to hear me today?
Yes. When how much time you want?
Not more than 30 minutes, whatever my friend says. My lord, kindly,
No one is there in the court.
Come at 2 p.m.
My lord,
because 2 p.m.
my lord,
some
could your
cooperative
lordship,
matters are there.
Yes, yes.
If it fails, I will be taking.
my lord, could your lordship take up on Thursday? At least give me a time, my lord, to respond.
This
My lord, he has taken, my lord, so much facts on issues.
document. You are ready with the matter. You have gone extensively.
But not that. My lord, kindly take it on. If it is tomorrow, I would be happy
Finish it
to.
off, Mr. Basu. Please finish it off. These judgments you are is well known to you. Only one decision.
My lord, I have to, my lord, there's a too short of time, my lord. Kindly, my lordship has taken so much pain, my lord.
Today is the best day. Otherwise, it has to go after the vacation. It's not possible.
My lord, I do not wish to, my lord.
Matters are fixed. Please do it today because today is the best day. From 2 p.m. you can come. There is some cooperative matters. If it fails, you can take time from that. If you want 2:30, I can keep it on 2:30.
My lord, I was above. I thought of to rush, my lord, or some other. My lord,
Please complete this.
very well, my lord. অসুবিধা
Lordship. I'm for the state.
I've considered the Constitution being judged. And also the last, before parting this court places on record. ডাকুন। For all yes.
Because there is no chance of taking up other matters. Item number 38 of interim order is till the end of July, April
Item number
38. Only your
38.
Yes.
Where is your other side?
On other side, he informed the Darika Mukherjee. He said that she will come. Now she has come back.
All right, wait. If for extension, I will be considering. Yes, call the list.
Item number 208.
What do you want? Please speak loudly. Please use the microphone.
I'm for the petitioner, my lord. I'm praying for a not today.
Not today. Yes.
Item number 209.
Pass over.
Item number 10.
Pass over next.
And I am for the petition. I am for the petitioner.
Nobody is there. Yes.
Achi, but nobody is there. Hey, petitioner, we are for. I am for the petitioner. You are the petitioner.
All parties are there.
All parties I do not know that I appear for. No, no.
Pass over next.
And I am for this one number 3 and 4, my lord.
Pass over next.
12 also 3 and 4, my lord. For this one number.
Pass over.
Sorry.
My lord, 10, 11, actual item number 10.
All parties are there.
My lord, I am appearing for the petitioner 211, 212.
But Mr. Bhattacharya, if all the parties are not there, it cannot be taken up today.
My lord, in that case, my lord may defer it 1 week after vacation because I have to go for undergo an operation.
200,
11 and
11, 212.
211 and 12 on the pair of the learned advocate for the
In
petition.
12 brought you.
Yes, next.
Under 13.
13 and 14, my lord. I appear for the cooperative bank.
What do you want?
Not this week, but I've just received the brief. Not
My lord,
this week.
213, my lord. I'm appearing for the petitioner, my lord. There is some urgency, my lord, in this matter.
I've
Kindly
just
get me.
received- I've just
My
received
lord,
the
I am
brief, my
praying
lord.
for a very innocuous prayer, my lord.
Kindly takes it up next week.
I
my lord.
appreciate, my lord, what my learned senior friend is saying. I'm praying for a very innocuous prayer, my lord. The facts of this case, my lord, may I only indicate briefly. My lord, I have taken, my lord, 3 loans from the cooperative bank, my lord. I'm willing to pay off the entire amount. A notice, my lord, has been given that I have to pay off this amount within a particular point of time. That's issued on my lord under section 122 of the Act, my lord. My lord, I am, my lord, a 65-year-old person, my lord. The property mortgage, my lord, is my residential property. Your lordship may may record my undertaking, my lord, that I'm willing to pay off the entire amount. I will pay off the entire amount, my lord. Kindly, my lord, grants, my lord, some interim protection insofar as, my lord, the notice of.
How soon can you pay off?
My lord, within my record, my lord, is not here, my lord, pursuant to instructions that I had taken, my lord, on the last occasion, my lord. Within a period, my lord, of 2 to 3 weeks, my lord, I can put at least 1/3 of the amount. The rest, my lord, I can secure, my lord, by way of valuable property that I hold aside from the property that's mortgaged, my lord.
Kindly takes it up on Monday, next week, my lord.
Next week,
Great.
yes.
13 and 14, my lord.
13 and 14 next week, yes.
Grateful, my lord.
If you can pay off the entire amount, well and good. Otherwise,
My lord, that's my instruction, my lord. I will pay off the entire amount, my lord.
yes.
13 and 14, next week.
Yes, next.
115. 116.
Appear for 260.
Pass over next.
117.
I am for the respondent.
218.
I'm for the petitioner.
Pass over.
18.
119.
Petitioner.
18.
Yes.
One 19. 120. 121. 122. 223. 224. 225. 226. 227. 228. 229. 230. 231.
32.
30, huh?
See,
Election Commission, Lordship, I 230.
all parties are here.
I appear for Election Commission. But all I do not know, I for election.
Passover next.
231, 232.
32, Your Lordship, I was making submissions
Yes.
in this matter, Your Lordship, regarding
I am
the
appearing for Election Commission, Lordship.
All the parties
parties
are
are
here.
there, the petitioner is there, Your Lordship.
I am for the state.
Lordship.
Yes, all parties are
All
here.
parties are there in 232.
231.
232 onwards.
On what?
232.
Yes. What is this matter?
33,
Your
34.
Lordship, this is that credit cooperative society where elections have been held and they hold their refinery and they were seeking that.
Yes.
I was making submissions, Your Lordship.
Yes. But where is Mr. Ahmed? I think Mr. Ahmed was appearing.
Where is there?
Yes. What do you say?
She will take note.
Yes. Then.
দাদা একটা সৌরভ শোনা হ্যাঁ হ্যাঁ
কেউ একজন আমার পাশে থাকুন, আমাকে হেল্প করুন।
ইয়েস বসো 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 ম্যাডাম
Sureka, after you, any party left or you are the last party?
Your Lordship, there are some added respondents.
Who is representing them?
One is represented by
Mr. Kamal Pathak.
Mr. Sanyal, one is Mr. Dipnath Roy Chaudhary and Kamal Pathak.
Can it be hard finally today?
Yes,
All the parties are not here. Peaceful hearing. What will be the use?
Your Lordship, I had made some submissions. I was to continue with the submissions.
But if the others, all the parties are not here,
They are supporting him. They are supporting him.
that I do not know.
No, they have their independent right of making submissions, Your Lordship. I shall not predict what they will
know who
do.
is supporting, who is opposing.
But we have already indicated on the other day that since Mr. Mitru has submitted, Mr. Jayanta Kumar Mitru, senior advocate, but we are adapting his submission, ballot. And a part of Mr. Sureka, because unnecessarily there is no use of repetition of the same points again, ballot.
That I do not know. If some advocate says I want to make submissions, I cannot stop them.
Then if my lord welcomes, I am ready to.
Your Lordship, if Your Lordship desires, it can be kept after elections, Your Lordship.
After the elections.
After the elections.
Fifth. So next is fifth.
Fifth will be
It will be after elections, after results also.
No, kindly make it 12th. Yes,
Your Lordship.
that Tuesday week, my lord. Fourth lordship, 12th will be better. Tuesday week.
Joint prayer of
Same, পরে মেয়েটাও সেম পড়িনি, 12th পড়িনি।
সব হয়ে গেছে। সব তো হয়ে গেছে। 232 থেকে 234.
232 তে, yes.
232, 33, 34 are
All three analogous matters, my lord. Two have.
আমাদের তো আর হবে না।
নামটা yes. Other matter, this start. This matter is.
I inform Mr. Mukherjee.
Ask him to come after Mr. Basu.
Yes, yes. Repeatedly try.
এদিক
Respond. Kindly text, my lord. Second supplementary affidavit.
Yes.
Page 14.
Second is that of March.
My lord.
Page
14.
14.
What was shown by my landed senior friend. It is a format of application of upgradation of school. Now, may I answer one by one? This is the first point, though it was not his first point, but I take it as a first point that how far it is very important, my lord, for my lords to have a consideration for the purpose of judicial review. It is a submission made from the bar that nowhere it is stated that in so far as page 14 is concerned, this format, my lord, does not say anything about with regard to providing of land. This from page 14 onwards, my lord, this format has started. Kindly comes to page 17. Middle of the portion, column 3 under part Roman capital 6. Proposal, if any, for extension of existing campus and or building. Lordship has found, my lord. Submitted from MZGR SH 31 DAG 134. Proposed for 1 acre land leased. In a very softer note, my lord, I may address to your lordship, my lord, that I have nothing to hide. And I would show, my lord, both sides of the coin. If something, my lord, goes against me, I would also show in my own way in order to have my lord's kind consideration. Now, my lord, keep that page. Kindly comes to page 20 of the same supplementary affidavit. On the basis of this application, the inspection was held at page 20. Lordship has found, my lord, 30/4/2019. Kindly mark this date. And my lord, before that, kindly also look to page 19 when the application was submitted, 22/1/2019 or 23/1. Lordship has seen, my lord, on the basis of this application, page 20, this was the inspection. A departmental process was initiated and inquiry was held on 30/4/2019 regarding upgradation of such and such school from high school to high secondary school. The school has 884 students from class 5 to class 10. There is a big computer laboratories with projector. Geography laboratory may be arranged in the school. There is no vacant room for class 11 and 12. So, shifting of classes from class 5 to 7 may be happened for introduction of class 11 and 12. There is a vacant space for construction of new building as well as second staircases which is necessary for upgradation. The SA has applied for fire NOC. This land has been recognized, considered, and also being measured that it is being traditionally used by the school for the purpose of conducting many events, which I have also shown Mellard and enclosed the document. Now, Mellard kindly turns to page 8 of the same supplementary affidavit. Why it is being so needed? 5th February 2007, the notification. Yes. Issued by the school education department. Now, Mellard, also at the same time, kindly open Mellard read petition, paragraph 5 at page 7. I have shown it on yesterday. This notification have specific pleading that how this cause of action emanate. Now, this notification I have enclosed in a second supplementary affidavit. Kindly takes up page 9. Yes. Inspection of school.
The mandate is that it has to be have a playground for the student. 5(2)(c). No school shall be inspected for the purpose of upgradation unless it is directed by the state government. So inspection was conducted since it being directed by the state government. Why the state government has directed? Because it was under consideration of the state government to promote me from secondary to higher secondary. There was a conscious steps taken, and subsection 2 says the district level inspection team shall inspect the schools in accordance with the orders issued under subsection 4 of section 8 of the Act, and shall also ensure that the school seeking upgradation shall 1 A, B, C. Well, I am on C. Now, Millard, also see Millard, section 6, subsection 3. Has your lordship got Millard? Director shall examine the inspection report. I have already shown to your lordship. And enclosures as may be forwarded by the DI and forward the same to the state government for issuance of necessary direction in the matter. That is what page 20 says about. That is the concluding part. That this is my inspection, that is what is needed. Which is necessary for.
What is the direction passed? What is the direction passed by the director?
Well, for inspection, that is why this inspection being done.
Shall examine. No, you have said 6.3.
Yes.
6.3 says the director shall examine.
Exactly.
The inspection report and enclosures as may be forwarded and forward the same to the state government for issuance of necessary direction on the matter. What is the direction? You have said that this is the direction.
Page 24.
Page 24. Yes. 24.
That was.
What is the direction?
Well, prior to that, kindly comes to page 21.
Yes, 21.
It was issued by the Assistant Secretary to the Secretary of West Bengal School of Higher Secondary Education.
Yes.
Kindly see the provisional recognition for upgradation of 8 schools, which includes mine also.
Yes, yes.
But you have seen, Millard?
Yes.
This is a type copy, is at 21A, Millard. 21A.
Yes.
Now, Millard, here from the top, Millard, third paragraph, necessary, this recommend second paragraph, recommendation stream along with subject has been proposed by such and such. What you have seen, Millard? Annexure B, the council may consider the list while approving the subject in the recognition memo for introduction in the next academic session. 22 is the Annexure B. Necessary measures for provisional recognition for upgradation of the said school may please be taken at the earliest under intimation to this department. Now, Millard, kindly see page 22.
22, yes.
We are at item number 3. In Kolkata, 2 schools were considered, one Bodottala and other is Gobra. And the subjects are also introduced.
Yes.
And these are all Millard, high secondary Millard stream subjects.
Yes. So where is it with regard to the playground? Where is in the recognition states about playground?
Kindly comes to page 30.
30, yes. Yes.
This page 30 says, Millard, what would be done with respect to Millard academic career.
That's a different thing altogether. Playground, where does it say anything in the recognition with regard to playground?
Of course, Millard, the rule itself provides, Millard.
No. Rule provides. But in the condition of recognition, please show me.
Millard, page 24 itself. Page 24 itself comes to.
Yes, please show me.
Mr. Mojumdar has shown page 24. My provisional recognition.
Yes.
Serial number,
It says about playground.
serial number 4 and serial number 7. That the institution will abide by the rules, regulation, and provision of the circular of the council from the time to time. That the provisional recognition accorded to the institution may be cancelled, withdrawal kept in abeyance if the institution fails to fulfill the above condition as well as other condition prescribed from time to time. This is the prescription I have already shown at page 8. And that is why, my lord, this I have been upgraded. Playground,
Now
my lord.
you have not provided with the playground. Till now you have not been provided with a playground. Your recognition is still there.
My lord, my provisional
It
recognition.
says about cancellation, automatic cancellation. But time to time it's been renewed. Why? What's the reason behind that? If you fulfill, it should be cancelled. It says that. Nothing on record to show that you have the playground, so it has to be cancelled.
My lord, page 20, if your lordship again, my lord, look back to that particular document, my lord.
Yes. Show me in page 20, it says about playground.
My lord, there's a vacant space for construction
Yes,
of
for
new building.
construction, not for playground. Not for playground.
My lord, but for the purpose of upgradation, playground is required. That the rule itself provided.
I'm asking you, show me with regard to the playground and that what steps have been taken against you for not providing the playground.
My lord, then kindly comes to page 12.
Yes.
Subject. Requirement of playground. Specified under schedule in the right of children of free and compulsory education 2009. The ministry has received representation from the state government such and such as specified under such and such. The right to, it has been stated that due to paucity of open spaces, specifically in metropolis and other big cities, in the crowded localities, etc., there are genuine difficulties in providing playground facility within the school premise. The matter has been examined in the ministry. The intent of inclusion in the playground as an infrastructural requirement of a school is to ensure that the children have sufficient open space for sports and other physical activities during school hours. It is not necessary that the school management provide this facility within the school premises. It would be sufficient compliance if the school management make adequate arrangement if an adjoining playground / municipal park, etc., for children to play outdoor games and other physical activities. Now, my lord, after this page 12, lordship has already seen page 20. Now, my lord, kindly comes to my lord, I am showing a document of annual academic calendar of 2026, page 31 onwards. My lord, may kindly comes to even that being, my lord, West Bengal Secondary Education Annual Academic Calendar kindly comes to page 35. Lordship has seen, my lord, serial number 4.
Yes.
Mandatory structure for framing of class routine.
35.
কোথায় দেখাচ্ছে? Now, my lord, under the subjects, health and physical education, Lordship has seen, my lord. Then again, health and physical education.
Art and work education.
Then, my lord, kindly comes to page 36. My lord, 6. Lordship has seen, my lord. আগেরটাও তো আছে প্লে না ড্রামা।
Yes.
Lordship is on page 35.
35 or 36.
36, yes. 35 I have already shown. Now see 36. Mandatory alternative activities to be held / conducted in school. Under that, my lord,
8 bullet point.
yes.
I've seen that. I've seen that.
Also on the next page. Next page.
36, 8.
My lord, a supplemental bullet point, my lord.
I can anticipate what submission you will be making when you take me to a page.
Well, this is my privilege and my lord, gratefulness, my lord, that
Yes.
I always extend, my lord, this.
Yes.
And my lord, page 37. Self-defense. Self-defense, page 37.
Page 37. Self-defense.
না এখানে খাটে হলো
Yes, yes. What are the activities you carry on? For this, all these you are performing?
Yes.
All
this we are performing and we have records
you have instructors for that. All these bullet points you have instructors for that.
My lord, there are certain police training programs also, my lord, being conducted.
For all these bullet points you have instructors for that. These and the next page.
We have instructors. We have instructors. This is my specific instruction.
What
We
is
have
the stop
instructors.
strength?
Staff strength, my lord, that we have also said so. কত staff strength আছে? My lord, in একটু এদিকে আসুন। My lord, that is also we have pleaded. I have found, my lord, in somewhere in the paragraph. As on date 29.
What is the name of your yoga teacher?
Structure care. Well, my instruction is from time to time, we appoint and engage yoga instructor and
What is
we
the
have
duration of time to time?
and we have
What is
specific
the
fund.
duration of time to time?
Well, as per the instruction of the funds provided in terms of SSN, there is a fund.
Frequency in a year. How many days you conduct this yoga training?
Well, so far as this taekwondo is concerned, that is being performed twice in a year. The training of taekwondo to the female student, that is being done twice in a year.
Yoga. Yoga training.
Martial art.
Life skill based activities. Value inculcations.
No, my lord, as on date, my lord, yoga has not yet been started. But so far the other, my lord, physical my lord, events, my lord, those
You
are
have
there.
in your academic calendar the music and dance classes.
Yes.
Please show me from your academic calendar. At page 35.
আপনাদের আছে academic calendar?
Please show me.
But this is the format that the Education department has provided, but we have not enclosed our own academic calendar over here. But if your lordship says, my lord, we can provide.
They have
Yes.
physical education, no dance class as per page 17. If I am not wrong, 17
Of the
of this affidavit. Page 17, kindly take, my lord.
My lord, I have not interrupted, my lord.
No, only
during
just to
his-
assist them, because
his
this is
submissions,
there.
my lord.
Dance,
No,
painting, it is not there.
yes.
Only
17.
Page 17, first language Bengali, second language English, mathematics yes, science, life science, physical science.
কোন পেজ দেখাচ্ছ তুমি?
17.
17 of
What the
Only physical education, work education, no
ah.
music, dance.
Yes. This is the particular
Mr.
related.
Basu, you can proceed in your
I'm sorry, man.
You can proceed in your own way.
yes, yes. Page 17 কোনটা দেখাচ্ছ? Second supplementary না first supplementary?
second.
Second.
এই যে টপে।
হ্যাঁ হ্যাঁ।
ডান্স পেইন্টিং মিউজিক এটা হয় না, এটার জন্য তো মাটি ফিজিক্যাল এডুকেশন। This is in my application for
এটাই পেলাম, ওই জানি না কিছু আছে।
It's very interesting. Page 36 and 37 points are very interesting.
This is what
conducted in a school, Mr. Basu. Artificial intelligence and machine learning, preparing museum in schools based on local resources. So,
absolutely, my lord, this is
news editing, content writing, visual arts. Interesting.
My lord, absolutely, this is very interesting, my lord. But
so,
this is
according to you, you are following all those.
Well, this
nice.
State resource department. This is how
Yes, let us proceed to the next. Yes.
My lord, may kindly takes up page 30 once again. 30. Lordship has seen, my lord, this document. Now, my lord, lordship, kindly see once again. This is a model which is, my lord, provided by the secondary education for the purpose of, it is not for me only, for the purpose of all schools to follow, for the purpose of administering and imparting education to the student. Now, whatever I have shown in between page 8 to 10, that for the purpose of promoting a secondary school to high secondary school, it requires ostensibly, my lord, a playground. And in page 17, what my learned senior friend has referred, at his submission, my lord, he did not show it. I show it, my lord, with my eloquence. And I say, my lord, it is apropos to these rules. 1 acre of land I have submitted. This is the proposal. And on the basis of this, page 20, an inquiry was being conducted in terms of the direction. And
so inquiry
here,
report,
page 17.
Mr. Basu, can you show me from the inquiry report anything about the playground?
My lord, there cannot be no inquiry report. There can be no inquiry report other than for ascertaining that whether the conditions to be fulfilled. What are the conditions? That is to have a playground.
Referring to a inquiry report, it says.
My lord, I am also referring at. I am referring strictly, my lord. I am on the application. That is a page 17.
No, page 17. You are referring to our inquiry report at page 20.
Yes. Now page
say,
20 comes when? When I submitted.
It says about many things, laboratories, other things, as well as the new
These are the what are the requirements? What are the other requirements? Kindly, my lord.
But it does not say about playground. I am telling that.
My lord, it may not have
correction by you.
No, my lord. I could not even say that. Now, my lord, it does not. It may not have said anything about playground. No, but I say the inspection was conducted for this purpose only, the primary purpose for, because that is the essential requirement. And page 8 that I have shown. It, my lord, says, my lord, in unequivocal terms.
I appreciate you say that as per the rules, this is required for that inspection was held.
Exactly.
No,
No.
my query to you is,
No, my lord.
it does not mention about playground.
No,
That
my
is
lord,
what
if it is
I
not,
wanted to ascertain.
if it is not mentioned, I cannot hide the document. I have to show the document and I have to try to improve. I say this inspection was carried out in terms of this requirement.
Yes.
And what was the requirement? That is 5, inspection of a school. The rule 5 also says about inspection. Now, for what purpose this inspection would be carried out? Inspection report may say X, Y, Z, but for purpose which the inspection is to be carried out, that is laid down under Rule 5. And Rule 5 consists that the school must have a playground. And it starts with the language with a non-obstante clause that no school shall be inspected for the purpose of upgradation unless it is directed by the state government. And these are the conditions that the school must have or should procure. And page 17, my lord, that particulars relating to the subjects taught in the school. What my learned senior friend has not shown, this is the subject what was at that point of time being taught.
It was not 11, 12.
When I was only secondary. For the purpose, upon being promoted to higher secondary, of course, my lord, I would be having other streams and subjects that I have also shown, my lord. Then what are the other subjects are to be included? These are at that point of time, life science, physical science, history, geography, work education, physical education.
Yes.
So I do not find, my lord, anything wrong subject to my lord's kind wisdom.
Yes.
These are, my lord, the headings, a particular relating to the subjects taught in the school. And page 24, after that, my lord,
Page 24.
24, this provisional sanction.
সাবজেক্টগুলো অ্যাড করা প্যারা 9 এটা এখনই আগে করলে 4টে সাবজেক্ট তখন এখানে নতুন সাবজেক্ট অ্যাড হলো
Yes.
In the same page 24, kindly see the last sentence at the bottom.
Yes.
These were the further subjects which were included.
philosophy, history, geography, environmental science.
And other than this, my lord, additional subjects I have also shown, my lord, at ওটা কোন পেজে ছিল
জানো তো যোগান মডেলটা
page 22. Lordship has already seen this.
All science and computer.
This education last 3 were additionally included.
কমাটা মানে কমা কি গো কমাটা অলফাটা ছিল সিওএম এটা হচ্ছে কম্পিউটার অ্যাপ্লিকেশন ও দেবজিরা সিওএম এটা কি কম্পিউটার অ্যাপ্লিকেশন কম্পিউটার করে থাকে
Yes.
Background library donor means it doesn't page number 36 onwards.
And my lord, after this page 24, 27, and 29.
Yes.
These are, my lord, shown as my renewal of provisional recognitions. Now, my lord, the conditions which are to be fulfilled, and also, my lord, stated at para 7 at page 24, which I have an expectation and the government, my lord, has taken steps to provide me such playground. And why do I need such playground?
My representations.
Writ petition হবে না?
Since 2017, I don't petition. Right.
Kindly takes up page 36 of my writ petition.
Yes. Actually, when I was not upgraded, is when I was in 56.
36.
Yes. Page 40. 40 to देखिए.
This is, my lord, why I need this playground. Lordship may see this also along with page 33.
33 was.
33, 36. Lordship, kindly see the prayer for getting near about 1 acre land from the backside of a school building for extension of the school building or new setup of playground.
Oh, yeah.
And I will be grateful, obliged if you cooperate with us to get the land for further extension of our girls' school. Hope your sympathetic look will this matter will enlighten this backward area. Now, may I kindly underline this is backward area. I will answer this whether it's minority or not. It's a backward area. It's in the Metia Buruj. And we know about the population over there. And I have also specific pleading. Mere not having a minority status, recognized minority school doesn't mean that I do not have minority students.
36 এর reply is 37.
And my reply to 36, এবার ওদের চিঠি দেখাচ্ছি start করো. Page 37. Prayer for Bodortola issued by
Secretary Government.
Assistant Secretary to the Government. With reference to the above, the undersigned is directed to send the copy of the letter of Bodortola with a request to send a detailed report on the subject land along with views of his department for taking necessary action.
2017, much prior to whenever. Yes.
That was on 30th June 2017.
Page 39 inspection. Same.
And apropos to this, my lord, page 39, there has been an inspection.
Also the WPLR manual.
The remarks of the inquiry officer, after having written order, I went to inquire the above scheduled plot, and there I found the plot was lying vacant and unused. The land is just adjacent to the above said school.
Page 40 for the representation. Page 41 at the relevant paragraph.
And page 40, my further representation in April 2, 2018, kindly turns to page 41.
The second last paragraph.
Second last paragraph. Our school possesses class 5 to 10 with 840 students and number of students are increasing day to day, but we have no playground or library room. Moreover, we are unable to start a HS section due to lack of place. I would be highly obliged if you cooperate with us to get the land for further extension of our girls' school. Hope your sympathetic guidance such and such.
Page 49 of the page 49 of the
Now, my lord, kindly now comes to page 49. Both the departments, my lord, were coherent. And my lord, were advised, my lord, that I should get this land. For which purpose? for the purpose of expansion of my school, for the purpose of a mandatory requirement that I must have a playground. Also may, for the reason, my lord, in that playground or in 1 acre land, I could also construct, my lord, I could also make some constructions whereby, my lord, I can have some rooms or not, but there should be a playground for the purpose of expansion of my school. And my numbers are increasing day by day. I am the only girls' school in that locality, and this is my specific pleading.
No, man, this is a document from the government recognizing that I am the only girls' school.
And my lord, there is also a document. কোনটা বলো? Yes, page 62.
Page 62.
This is a government recognition that it is the only girls' school in the area.
2024.
In 14/3/2024.
Third last one. Fourth last one.
First, second, third, fourth paragraph from the top. And whereas Bodortola such and such, established 1965, is a girls' school having 948. So by the time my students are increased, 15 assistant teacher, Lordship was inquiring about. This is a recognized. They cannot deny this document. 2 non-teaching staff, and it is a government-sponsored school and the only girls' school in Bodortola area.
Yes.
And the last paragraph, madam. Just before, this is for your kind perusal. It is also state that a proposal for settlement of 1 acre of land at Dag number 134 in favor of Bodortola for extension of the school has been sent to the additional secretary with a memo 11/2/2021 from the end of the school department, which was fortified even in March 2024. And in the meantime, my lord, I was given a provisional recognition for imparting higher secondary education. So I am here, my lord, in order to have a judicial review on this departmental process. To have my lord's own wisdom to ascertain, my lord, what happened there.
Why didn't I get the
My land requirement was for a benevolent purpose. This was not for any private, my lord, for any private enrichment. It's for a public use.
all my teachers are government?
It's a government sponsored. Now kindly comes to my writ petition paragraph. My learned senior friend Millard was trying to show Millard and impress the honorable court. May I also, Millard, have Millard, my lord's kind wisdom, Millard, to read Millard in my own way that why I require this. Paragraph 1. My senior friend has shown, Millard. The petition number 1 is a government-aided school, 5th to 10th. At present, the government-sponsored school and has been continuously functioned for 6 decades, serving over 950 girls students, mostly from minority. I say mostly from minority. And it is an admitted fact, it's in a Metiaburuj area, an economically weaker background. And I have shown, Millard, from the government document, it's from the backward class. And has been persistently petitioning since 2016. It is a juror such and such, that who is one of the member, education such and such. Now,
annual school fees is 240 rupees.
kindly comes to paragraph 3. Paragraph gulo bolo. Since 2016, Lordship has seen, the petitioner has consistently approached the competent authority for allotment of 1 acre of land in Dag number 134. It is pertinent to mention here that the girl students at the petitioner school have been using the said school as playground from the inception of the school. This is my positive case. The said land, which is adjacent to the school, has been used by the students for a quite long time for playground and also for alternative egress and ingress to and from the school in its rear side through Abdul Khabir Road, opposite to Nadial PS side, to avoid traffic congestion in Bodortola Bazar to enter into the Riverside Road. The girl student used the playground and passage through the vacant ground to the old dilapidated gate of the jute mill leading to such and such road without any hindrance. The petitioner also has the said land for conducting the annual sports year after year for a quite long time. I have also documents to show, my lord, where many state dignitaries, my lord, are used to come over there. The said parcel of land in question has historically been recorded as lying idle and unused. Then para 5 I have already shown, my lord. Then sorry, kindly comes to paragraph 16 at page 12. It is deeply concerning that such a purported sanction and lease have been used after the government itself had recognized and processed to articulate the petitioner's request for allocation of a portion that is approximately 1 acre of the said land. The record reflects contemporaneous multiple official memoranda, survey reports, and departmental communications over the period 2017 to 2024, which explicitly unequivocally acknowledge the petitioner's genuine requirement and prima facie eligibility for settlement of the said portion of the school extension and playground purpose. Such would facilitate promoting minority education which are guaranteed by the Constitution of India. This is apropos to my submissions. And on the same line, my lord, kindly check, my lord, and test. Wherever I am wrong, my lord, kindly throw me out. Kindly comes to, my lord, prayer A and prayer C. What happened in the meantime? And this is something it is not
to be inquired into.
That is to be tested. My lords is having a writ of certiorari, this jurisdiction. My cause is something different. I have nothing to say, my lord, whichever XYZ, my lord, has taken whatever the things from the state government. My purpose is very limited and very straightforward. I have only, my lord, only one eye to see. I don't need to see the entire world. My only one eye to see. That the land.
One eye to see.
One eye to see. Only one eye. There's art of
See that.
Third eye.
That's the bird's eye, my lord. In precisely as a bird's eye. I don't want to see the entire world like them.
Just a digression. One eye leads us to only one conclusion: Cyclops, the monster.
My lord, I would always like to see, my lord, that the bird's eye. Let them happy with the entire world. I don't want that. And
This has been granted in their favor.
Yes.
yes, that is what my instruction is this, which comprises of
Mr. Basu, how can that a portion of that property given to you now?
my lord, that would be
How? By what mode?
my lord, that is for the state to decide.
I'm asking you. What is to be done with that lease? Maybe whoever has to do that, what is to be done now? Now, good, bad, indifferent, rightly or wrongly, a lease has been executed in favor of a third party.
I am questioning the departmental process.
You want a portion of that property. How that can
Not a portion of the property. I want a portion which comprises 1 acre, which falls in 134 dak.
I'm telling that. So within that leasehold property, you want a portion of that 1 acre. So now, by what mode it can be given? I'm asking you.
No, my lord has considered and said it in one way. I say, my lord, in
I'm asking you.
yes, yes, of
It has
course.
to be- after all, if I'm with you, a way out has to be taken. So, what is to be done now? What is the ultimate relief which is to be granted? How that is to be given effect to? Even
But-
if I hold, yes, it was wrong done to you, you are entitled to, then what should be done then?
My lord, to be very fair and transparent, my lord, the state has to consider this.
Mr. Basu, yes, what should be, let us. now
State has
state
to
will
find
also
out
not
a way.
consider. If a writ is issued, what should be the direction now? If I am with you, what direction should be passed to redress your grievance? All your submissions are accepted, wrong done to you, you want a playground adjacent to that in plot number 34 or 134, everything is in your favor. Now, how that can be given to you? I'm asking you.
Millard, my answer may be, Millard, in one sentence, that state has to, Millard, find out a way that how this land, that is for the state to answer. That is for the state to answer, because my right accrued.
State will say, I've given them this lease, then what can be, has to be done? What order should I pass to protect your interest?
Millard, that is again, Millard.
I accept all your submissions. Yes, this school requires 1 acre of land and a wrong was done by not giving you. But good, bad, indifferent, a lease has been executed in favor of a third party. Now, how to give it to you now?
Millard,
But I'm asking you, what is the modus operandi? I have to consider that also.
Millard, that is all.
Because you want the ultimate relief.
Yes.
Merely by holding, no, state has not done this,
Yes.
not done that, that will not give you an ultimate relief.
Right.
So what is the relief you want now?
Millard, my ultimate relief, Millard, the state has to, Millard, give me 1 acre land, which is
From that property.
contiguous. From that 134 tak.
Yes.
I do not say from that property. I say from 134 tak.
Sir, Basu, don't beat about the bush. Please, 134 is within the lease. Let us, so that's not disputed. So if you want 134, a portion of that, it has to be from a property which is the subject matter of the lease. Now, by what mode it is to be done? Whether the lease has to be cancelled, whether the lease has to be modified, by what process it is to be done?
Millard,
I
that,
want to know the process because while delivering the judgment, I have to do that if I hold in your favor.
Millard, that the legal solution, Millard, that I could not say, Millard, that how it could be done.
Then how can you give relief to your client if you can not say what is the relief you want?
If Millard,
Everything is in your favor, but not the ultimate relief. What's the ultimate relief you want?
Millard, if may I say this?
If it is held, yes, you are entitled to that. Everything state proceeded with that, everything on that. But state acted illegally by not giving you. Now, what order should be passed now? All your submissions are accepted. Mr. Mojumdar's submission is rejected.
I can understand, Millard, what your lordship, Millard.
That is troubling me, Mr.
That is
I'm
also
telling you,
troubling me.
please make submissions on that because I have to pass a final order. If I hold everything in your favor, what is the ultimate order I have to pass? Because you want to give relief to your client by saying, yes, state has done illegally, yes, done, I stop with that. It will not help your client. So what is the, because good, bad, indifferent, rightly or wrongly, lease has been executed. And
Yes.
you do not want the entire property, you want a part of that
Yes.
sold property. So what is the mechanism, how it can be given to you?
There's mechanism in the deed itself. State can.
Millard, as your lordship has pointed out, Millard, there's good, bad, indifferent, a lease is being executed, rightly or wrongly. And my claim, if
It is allowed, accepted.
is allowed and accepted,
Yes.
then of course,
Then how
Millard,
relief can be granted to you? Or what relief can be granted to you?
and I don't have any alternative, Millard, land.
Yes.
I have only, Millard, requirement for that
Yes.
land
So
only.
how that relief can be granted to you? What should be the order which is to be passed?
Millard, the state has to, Millard, allocate me that land, Millard, and in the,
How? I'm asking you what mode?
Millard, may I just
State will
answer?
not give. Court has to pass an order. State will not give. If the state would have given, it would have given to you. They will not give. So what order shall I have to pass then?
Millard, there are certain other lands which are also there
Beyond the leasehold property.
beyond the leasehold
That's
property.
another thing. You want that?
No, no,
Or
no.
you want this property?
I want
What
this property.
This property, I'm asking you, what is the mode? If you want other properties, situation is different. Mr. Mojumdar is not concerned. That's a different thing altogether. If you want a portion of this property, if you want a different property, it's a different thing altogether. But if you want this property, particular 134 or any portion within that leasehold property, what order should be passed? That's what troubling me. Even if I accept all your submissions, what order shall I pass? Please assist me on that.
My lord, may kindly comes to, my lord, may I address to your lordship this issue? I have other points, my lord, to show. Kindly, my lord, for my lord's query, my lord, I have a duty to show. Kindly comes to first supplementary affidavit, page 21.
Yes. Page 21.
20.
Yes.
Clause 16.
Deed.
That is a part of the deed.
19th January.
Yes, 19th January.
19th January.
Page 21.
Page 20.
21.
21, yes.
Clause 16.
Yes. Yes, clause 16. What is the submission on clause 16?
My lord, this clause 16, my lord, provides, my lord, yep, my lord, any portion or part of that property, my lord, may be taken by the state government, my lord, for any public purpose.
That's their decision. Can a mandamus be issued for that?
My lord, if
Their decision, whether they will decide or not decide, can a mandamus be issued? Yes, you decide in this way, you do this.
no, my lord, lordship may not, but lordship may certainly.
Then a mandamus, so I cannot pass an order directing the state, yes,
No,
you require this
lordship,
for a public purpose,
no, lord,
take from them. Mandamus cannot be issued.
no,
So I'm asking you, I want to have a way out. What order I can pass?
no, lordship may certainly, my lord, look into the departmental process. And if holds, my lord, may I just complete? If my lord holds, this departmental process has to come to a logical conclusion by allotting this 1 acre of land and acting another way. The state has done, my lord, something wrong, and the entire execution of the lease deed comprise of that 1 acre is bad. That is what, my lord, my prayer ANC. Then automatically, my lord, my entitlement, my lord, would come forward.
Order, a mandamus is to be issued directing the state to?
My lord, to have a process of this logical conclusion, my lord, to come to an end. My lord, apropos from
To act in
2007.
terms of clause 16 of the lease deed.
No, I do not say that. My lord, so far as clause 16 is concerned,
Pointed out clause 16, that is what I.
no, my lord, that is, I did not want to point out this, since, my lord, I do not want to, my lord, go into that lease deed my lord, at all. My point is this, my lord, that you, as your lordship has pointed out, that if I pass an order, then what would
order
be
I
the
should
way?
pass?
What order? Then, my lord, in that way.
Give you relief. To give you relief that 1 acre out of 130.
Exactly, my lord. If the departmental process is ultimately, my lord, giving, my lord, the land in their favor is held to be bad, my lord, then automatically everything goes. My question is only to that extent.
They are favored by virtue of this lease deed.
No, by so far as this 1 acre of land, not giving me and what.
1 acre is comprised within a chunk of property. 1 acre is a portion of that. So,
My lord, I restrict myself
part
to,
cancellation of the lease deed.
my lord, so far as
Part
only,
cancellation of the lease deed.
my lord, so far as this this not giving this 1 acre of land to my favor.
Yes, I followed. What order should be passed? cancellation of the lease deed to the extent of 1 acre.
Maybe, my lord.
Thank you. Yes, now you can proceed.
Now, my lord, kindly comes to
এটাকে করে লাগান এতবার so many times I have to turn over those pages. Yes, Mr. Basu, you can place. Yes. Just switch off those microphones while holding.
No, no, no.
So that it does not come within the years of the code.
Now, my lord, if you
Mr. Mojumdar cannot hear that.
I do not say anything about Mr. Mojumdar, but Mr. Chakraborty is very enthusiastic.
Now, it helps us, online hearing. We can hear the division bench, the judges talking lot from the phone, but normally in courtroom it is not audible what the honorable judges discuss in between.
Yes, Mr. Basu, you can proceed.
The mind of the honorable judge.
Now, my lord, kindly takes my lord 323B.
Yes.
The major portion of Mr. Mojumdar's argument is that I have also remedy before the tribunal. I say I have only remedy to this court only. So, my lord, and this is the submission, my lord, that these are the constitutional remedies. The constitutional remedies also with certain limitation. 323B, tribunals for other matters. Now, my lord, kindly comes to subsection 2. The matters referred to in clause 1 are the following, namely. Now, my lord, we can only, my lord, see D, nothing else. Now, other than D, the tribunal has nothing to look into. If anything concerns and adjudicated by the tribunal, that would be, my lord, of course, my lord, offshoot to their jurisdiction. He cannot even look into. So far, the lease is concerned.
Not follow this limb of your submission.
My lord, the tribunal cannot look anything other than this 323B sub-article 2.
Yes.
Now, there, my lord, this
tribunal has been constituted for this purpose.
For this purpose. Now, I have no issue with regard to D. So far, the others are concerned, those are not relevant and do not come into.
D and H. D and H are there. H does.
My senior friend says H. I do not find that H is relevant. It's relating to landlord tenant. So it's only land reforms by way of an acquisition by state of any estate as defined in Article 31A or of any rights therein, or the extinguishment or modification of any such rights, or by way of sealing on agricultural land, or in any other way. Now,
according to you, your claim does not fall within land reforms.
My claim does not at all fall within the scope and ambit of land reforms.
I followed that.
And now, my lord, the judgment, the asset reconstruction.
Yes.
The citation and reference is wholly misplaced. If may I say, my lord, in a very softer note. Yes. My friend, my lord, senior friend has referred to para 54. My lord, kindly, before that, kindly, my lord, consider what was the issue. Issue is a deed cancellation has to be done by the civil court only, not by the writ court. Single bench has quashed, annulled that deed. Division bench reversed. Supreme Court reversed division bench and restored single bench. Meaning thereby, the cancellation of deed by the writ court was accepted by the Supreme Court. I do not know, my lord, how, my lord, this is being relied on. Again,
cancellation I could not follow. Cancellation of the
deed. That is the proposition. Of a execution of a deed.
Yes.
That was challenged in a writ forum.
Yes.
So the law is cancellation of deed has to be done before the civil court, not by the writ court. But the writ court has cancelled it. division bench reversed. But Supreme Court again reversed division bench and restored single bench.
Show me that.
Kindly comes to Millard. Paragraph 3.10.
3.10, yes.
My lord. Eventually starts from page 13. Lordship has seen, my lord. 3.10.
This is the Registration Act of which state?
My lord.
1908. Registration Act.
That's relevant because which state?
No, Registration Act of 1908. Registration Act of 1908.
Some amendment in some states.
Yes.
Which gives the power to the registering authorities to decide on these issues.
Exactly.
That is what.
Exactly.
This is pertaining to which state?
Okay, okay, well, I follow. This is pertaining to Tamil Nadu.
26, your lordship will get.
Tamil Nadu.
Tamil Nadu, and the amendment made by Tamil Nadu has been considered.
Please show me that amendment.
26.
Yes.
Malad, para 26 at page 22.
Paragraph 26. Yes.
This is the additional provision.
Subject to the provisions, no document shall be registered unless the documents executing such documents in the case assigns or appear before the registration authority.
Now, Malad, also see para 27, 28.
Inquired, essentially, they have inquired final decision was not inquired in today.
My lord may also see 27, 28.
Only failed to yeah, that was the challenge. So more on the physical execution of the deed.
Eight. শুধু বলেছে অলরেডি একটা কমিশন
But a deed has to be
ঠিক ঠিক আমরা কত কিছু শিখতে পারি ভালো সৌভাগ্য
Yes.
Now, Millard, kindly Millard comes to paragraph 3.10. The entire issue, what was before the writ court, is being Millard noted there. 3.10 at para 13.
Then come straight away to paragraph 57.
Excellent. 57, 58. And there, even my page is also open there. And my senior friend has shown 54. 54 has to be read along with 53.
Yes, sir, absolutely.
There are
Yes, yes,
three
yes.
three
No
things.
dispute on that. Yes.
So my friend has only shown 54 last portion. And the last penultimate paragraph at page 65. Where therefore in fine the appeals are allowed, the impugned order division set aside, and order of the single bench is singly registered.
The law laid down is that paragraph 57.
57.
That's the law which says for which it has to be gone to civil court,
Yes,
for
yes.
which
For which
petition is maintained.
64 is a relevant paragraph.
My lord, in addition to this, if my lord also looks into paragraph 60, there also the laws laid down that on the case on hand, the appellant has not sought a declaration from the High Court that the execution of the document in question was null and void, or that there was no title for the executant to transfer the property. The appellant asserts before the High Court only the act of omission on the part of the registering authority to check out whether the person who claimed to be the power agent had the power of conveyance and the power of presenting the document for registration, especially in the light of the statutory rules. Therefore, the learned judge rightly applied the law.
Substance, Mr. Basu, is that there is a failure on the part of the registration officer in performing his duties under the Registration Act. You challenge only that writ petition. If you challenge the document as a whole, null and void, you have to go before the civil court. That's the distinction made in this.
My lord, in so far as this judgment is concerned, my humble view is that this judgment is not applicable over here on the given facts of the case. This judgment is wholly misplaced. It only says about in which way the High Court should entertain and which way High Court should not entertain. Here my submission is that I have a only remedy. Even if that 323B is looked into the constitutional limited powers of the tribunal, that is being restricted to subclause D only. He cannot look into the documents issued by the education department. He doesn't have even authority and jurisdiction to consider that what are needed in terms of the education rules, what are the requirement and why the inspection was being carried on, why the inquiry report was submitted, and what was the conjoint steps and the departmental process being initiated side by side by both the departments of the state of West Bengal to accord and sanction that 1 acre of land. This cannot be looked into by the Land Reforms Tenancy Tribunal. And I have no quarrel with regard to the lease deed executed. I have nothing to, no prayer is sought for. If I do not have any prayer sought for.
Challenge that, Mr. Basu.
And
Relief can be granted to you. That is the difficult thing.
My petition as it is, what is there? And kindly have a look to. ভাই একটু সুযোগ একটু আস্তে কথা বলবে আমি তোমাদের সাবমিশনে কখনো জোরে কথা kindly see
please control your junior. Yes. Or you cannot also control him.
Impatient boy, but good boy.
You cannot control him.
No, he's a good boy. A little bit impatient.
He is so fortunate that he has his. I say, I am not fortunate. A document, to be very fair and honest, Lordship may go in my client's favor or may not go. But that doesn't say that I say something wrong. Because Lordship is always with us. Kindly see para 53 of that judgment again, of this asset. A document is to be challenged when these three conditions are being laid down. If there is nothing wrong, a document also cannot be challenged.
You cannot follow that. How does it apply in your case?
No, kindly look into this paragraph 53. This is a lease deed is being registered.
Yes.
Now, this para 53 provides para 54. Kindly read to the last part.
Yes.
A challenge to the very execution of a document is a challenge to its very DNA and any effect or illegality on the execution, any defect or illegality in the execution is congenital in nature. Therefore, such a challenge by its very nature has to be made only before the civil court. Now, there are three parameters. 53 says actually the registration of a document comprises of three essential steps amongst others. They are
third step is with regard to the you can challenge. Yes. 2 steps considered in paragraph 54. Yes. And
The
third step,
act of registration.
concluded in paragraph itself.
Act of registration. Now, my lord, as on date, my lord, I do not have any relief against them. I do not have anything to say against them.
You do not have, Mr. Basu, please understand. Please understand the difficulty of the code. If you say I do not have anything against them, how can I pass a order against them and grant relief in your favor?
My lordship would not
That's the
require
very
to lordship would not require to pass any order against them. Lordship, I have prayed, my lord, pass an order against the state
that will be affecting
for their culpable, my lord,
Mr.
omission.
Basu, that will be affecting some of their right which they have.
My lord, that the state has to compensate or state has to do, my lord, whatever the needful.
Mr. Basu, that's a different thing altogether. But for that, something has to be taken from their property.
Well, maybe,
Yes.
maybe,
So,
of course.
Yes. So if that is to be done, so whether the document by which it is being done, that should not be under challenge.
My lord, I have not challenged that.
That is why.
That is why, my lord, I have
that-
challenged the
That
process.
is why failure to disclose a cause of action. I am on that. Because maintainability will be on the issue what relief is to be granted. What's the ultimate relief is to be granted? That is why I'm trying to harp upon you. What relief the court will grant in your favor. Even everything what you are submitting is in your favor.
My lord, the cause of action is, my lord, as I have learned from the lordship, is a bundle of
Action
facts.
leads to the, for which leading to the relief. What relief will be granted?
My lord, the relief that is being very explicit terms, my lord, are there at prayer A and C.
Please see, please read that. Please read that.
And my lord, also to kindly see, my lord, prayer E.
How
Prayer
this thing
E.
is to be granted
My lord,
without affecting their right. You are not challenging that.
my lord, kindly comes to prayer E at page 28.
Yes.
Issue a writ of
Now you have challenged. This late is executed. If you have challenged that, so that is to be modified. That is what I want to know from you. So that least deed you are saying, I'm not challenging, I'm not in a way affecting whatever is being given to you. That's very challenging that. I wanted to know from you, what's the relief?
That is, of course, my lord, in my way.
Otherwise, you cannot get any relief unless their lease is affected.
Of course, my lord, I do not even say otherwise. What I say, that directly or indirectly or by of doctrine of necessary implication. My lord, if something is to be considered or taken away or some portions are being, my lord, reallocated, it is only for the state to look into. I have no basic grievance or basic challenge with regard to the lease.
Cannot say, because in view of prayer,
My
you
lord,
challenge that lease.
no,
How can you say you do not have anything against them?
my lord, here, my lord, what I have
trying to take, Mr. Basu, you are trying to it appears that something is in your mind, you are not trying to get it out of it. That's the difficulty. Because when you want to take something which has been given to Mr. Mojumdar, so he will be affected by that. So unless that is affected, that is modified, something cannot be given to you. That you are not trying to understand.
Well, I have understood. But what I am trying to say, if this lordship, well, this purported sanction and lease deed, what I have said so. Well, prior to that, I have said that so far these original records and the file notes and the sanction proposal, inspection reports and all documents pertaining to the petitioner's application, reconstruction survey proceedings. So that has to be looked into, and if that is being undone, so the automatic process is, my lord, that the lease deed may have to be also modified.
That's what I want to know. Lease deed has to be set aside or cancelled.
Or modified. To the extent. And even in that case.
That's what I wanted to know.
Even in
that has to be modified or not.
Now, my lord, that part, modification or cancellation or setting aside or nullifying, whichever it may be, that would be a proximate effect. That could not come, my lord, as a fund.
Consider at the time of integrity.
My lord,
because which court has jurisdiction for the purpose of granting relief, that is to be seen.
no, of course, my lord, that is what I am saying. Now, why I need this? For what purpose, my lord, this is
That you have
required?
explained. Why you need that, you have explained.
My lord, this, my lord, cannot be looked into by the Land Reforms Tribunal.
The grounds that will lead to that cancellation cannot be heard by the tribunal.
So far as if at the end, my lord, it is to be held by the court or my lord, the tribunal that this is to be cancelled, then the grounds for which, my lord, I seek in other way, my lord, this modification or cancellation cannot be considered by the tribunal.
We'll never get that relief.
The tribunal cannot see beyond this execution of this document. If the tribunal holds, and tribunal if can only hold that just to see whether this execution was proper or not. If the execution is proper, the tribunal may not have any jurisdiction to look beyond that. The tribunal could not have seen beyond 323B that the state has committed a fundamental error in not providing me the land, and also in the light of Article 29 and 30.
It was granted under what provision?
Well, according to the lease deed, well, it was granted under Section 4B.
4B of the Land Reforms Act.
Land Reforms Act. That Mr. Majumdar has shown, my lord, I have also shown under the 4B. My lord may take, my lord, second supplementary affidavit. Page 9.
Not supplementary reading. Not supplementary reading. Yes. Not supplementary.
More, Mr. Basu.
My lord.
Reply is even lengthier than the submission.
My lord, my Mr. Majumdar is being permitted to say, but I have not even touched the. Well, I have not even touched the facts.
That's what you will touch. Facts you have argued in extensive. Don't touch on the facts. Look, all the pages have come out.
No, my lord.
Don't turn over the facts. All the pages have come out. I've asked my officers to stitch it. Now it doesn't. Please don't go to the facts.
Now we can also do stitching, my lord.
Yes, facts you have argued at length. So law points, anything you want to make submissions? Because Mr. Majumdar has cited two decisions, L. Chandra Kumar and
asset reconstruction.
Asset reconstruction you have taken.
Gaur Chandra Ghosh. Gaur Chandra Ghosh.
Gaur Chandra Ghosh.
Gaur
If you want to make submissions, you can make submissions on that.
Millard may kindly take up L. Chandra Kumar once again.
Yes. After all, it may not be relevant because according to you, it's not an alternative remedy. 226 is the only remedy. So if that is so, these decisions may not be.
And Millard, I would also like to add
but
this.
Since Mr. Majumdar has.
Yes, and I would also like to add this, Millard, with my own humble way, that even if it is
for 1 minute, Millard, I'm just coming.
That even if Millard exercising my lord's extraordinary power of judicial review, Millard, the part of a deed is to be looked into and to be considered.
I could not part of it.
Deed, the lease deed, Millard, which according to Mr. Majumdar can only be questioned before the tribunal. Millard, that is this challenge is a composite, or it's something Millard is out of way that that the lease also may need to be looked into. This is not the sole criteria that I have only challenge on the deed. It is not that that we are fighting at loggerhead. I have a different cause of action. My process began much before that.
Don't argue on facts. Yes.
Now, if Lordship looks into page 7, paragraph 78 of this L. Chandra Kumar, Lordship has seen one part of the submissions that what this is the constitutional power. Now, this constitutional power are limited, as I've said, but so far my lord is there. Page 70, para 78 says the legitimacy of the power of a court with constitutional democracies to review legislative action, Lordship has seen, has been questioned since the time it was first conceived. The Constitution of India, being alive to such criticism, has, while conferring such power upon the higher judiciary, incorporated important safeguards. An analysis of the manner in which the framers of our Constitution incorporated provisions relating to the judiciary would indicate they were very greatly concerned while with securing with the independence of the judiciary. These attempts were directed at ensuring that the judiciary would be capable of effecting discharging its wide powers of judicial review. While the Constitution confers the power to strike down, lays upon the High Court and the Supreme Court, it also contains elaborate provision dealing with the tenure, salaries, allowances, retirement, such and such. The inclusion of such elaborate provisions appears to have been occasioned by the belief that, armed by such provision, the Superior Court would be insulated from any executed and legislative attempt to interfere with the making of their decisions. The judges of the Superior Court have been entrusted with the task of upholding the Constitution, and to this end have been conferred the power to interpret it. It is they who have to ensure the balance of the power envisaged by the Constitution is maintained, and that the legislature and the executive do not, in the discharge of their function, transgress constitutional limitations. I am on this. It is equally their duty to oversee that the judicial decisions rendered by those who man the subordinate courts and tribunals do not fall foul of the strict standards of legal correctness and judicial independence. The constitutional safeguards which ensure the independence of the judges and superior judiciary are not available to the judges of the subordinate judiciary or to those who man tribunals created by the ordinary legislation. Consequently, the judges of the latter category can never be considered full and effective substitutes for the superior judiciary in discharging the function of constitutional interpretation. We therefore hold that the power of judicial review over legislative action vested in the High Court under 226 and this Court under 32 is an integral and essential feature of the Constitution, constituting part of its basic structure. Ordinarily, therefore, the power of High Court and the Supreme Court to test the constitutional validity of legislation can never be ousted or excluded. Now, my lord, here, my lord, considering this paragraph, the tribunal can only look into the deed, nothing else. But my lord's power, my lord, is unbridled.
Jurisdiction is also very wide. Can also decide the virus of the state, accepting the parent statute by which it was created. Everything. Don't say it can only go to the.
But
power is wide.
My lord, even if that be so, but my case, my lord, does not fall that.
You are saying he can only consider that, no other issues. It's not that.
No, he can also look into the virus. He can also look into the virus.
Why? It has been said, because please conceive of a situation, all these matters, before this setting up of this tribunal, land reforms and tenancy tribunal, all these matters were dealt with by the High Court before the single bench against that inter-court appeal. That was the scheme. Now the tribunal took away the jurisdiction of the single bench. It says single bench jurisdiction has been excluded by virtue of Section 8. And here L. Chandra Kumar says that it plays a supplemental role. That is why it says it cannot be a substitute. It plays a supplemental role. Tribunal will be the court of first instance, and against that judicial review. That is why, because all matters which were pending before the High Court, single bench, all were transferred.
What
the High Court used to decide under 226, All those were transferred.
Exactly.
So same powers. Do not say that could not have done.
No, my lord, maybe, my lord, I,
Just think of a situation today.
yes,
Uh,
I stand corrected, my lord.
WPLRTT was not there.
Exactly.
If the tribunal was not there, this matter could have been decided. And let us think of a situation now after subsequently it has been created and it's transferred. This matter would have been transferred. So don't say only that limited part cannot decide other things. What under 226 the High Court single bench could have decided, all those have been transferred.
My lord, with
Whatever way you say, what could have been argued here can be argued there. Don't make that submission because this is against L. Chandrakumar what you are submitting.
no, my lord, this is, my lord, again, my lord, I put it in my way, my lord. The tribunal can certainly decide, my lord, within the powers which are there.
That's a different thing. That's a different thing. And if you say that it's
Yes,
not
yes.
within this tribunal's power, then it will be not be under Group 1. Then it will not be under Group 1. Will not be under land. Not be under land then. That is why on the very first day I told you. If you say Group 1, then if it falls within that, it has to be there. Otherwise, if you try to bring it out, then it cannot be Group 1 also. You have to be very cautious in making your submissions because if you go to another, it will take it out of Group 1.
That cannot be done.
Yes. Any other paragraph of this judgment you are to rely upon?
My lord, may also, my lord, look into paragraph 93.
Yes. Yes, this paragraph 93.
This is what your lordship has also held, my lord, in my lord's judgment.
This paragraph 93.
Before moving on other aspect, we may summarize our conclusion on the jurisdictional powers of this tribunal. The tribunals are competent to hear matters where various of the statutory provisions are questioned. However, in discharging this duty, they cannot act as substitute for the High Court and the Supreme Court, which have our constitutional setup been specifically entrusted with such an obligation. Their function in this respect is only supplementary, and all such decisions of this tribunal, that is what your lordship has also held in Gaurchandra,
I have not held you. I have only followed this.
and will be subject to scrutiny. And here, my lord, may I just pause your lordship for a moment, my lord? My submission has been very consistent from the first day that this, my lord, matter, which is before, my lord,
Does not fall within 1997 Act.
1997 Act, and I have no issues to be espoused before the tribunal. It doesn't fall
you have
within such
submitted.
category.
That you have submitted, yes.
Their function in this is only such and such. The tribunals will consequently also have the power to test the virus of subordinate legislation and rules. However, this power of the tribunals will be subject to one important exception. The tribunal shall not entertain any question regarding the virus of their parent statute, such and such, which is a creature of an act. All other decisions of these tribunals rendered in cases that they are specifically empowered to adjudicate upon by virtue of their parent statutes will also be subject to scrutiny before a division bench of the respective high court. We may add that the tribunals will, however, continue to act as the only court of first instance in respect of the areas of law for which they have been constituted. By this, we mean that it will not be open for litigant to directly approach the High
Very
Court.
important. Please place it.
We may add that the tribunals will, however, continue to act as only the court of first instance in respect of the areas of law for which they have been constituted. By this, the High Court, we mean that it will not be open for the litigant to directly approach the High Court, even in cases where they question the virus of statutory legislation, except as mentioned, where the legislation which creates the particular tribunal is challenged by overlooking the jurisdiction of the tribunal concerned. Now, this would only applicable to the extent, my lord, that if I question any act
Yes,
under this.
that's not this in dispute.
Well, my
Here it says, even in challenging the virus, you cannot directly approach the High Court.
only the validity of the act, validity of the Parent Act, by which that cannot be questioned.
Because that's elementary. The act by which you have been set up, you cannot decide the validity of that.
Now, my lord, here my specific pleading, to the extent, my lord, that my constitutional rights are being, my lord, as being fundamentally protected, Lordship may kindly look into paragraph 24 and 25 of the writ petition.
Yes. Yes, anything on the other judgments? Yes.
Para 29.
Yes.
The petitioner have no other efficacious alternative remedy excepting invoking the extraordinary constitution.
The usual paragraphs, 2 or 3 usual paragraphs, those in all writ petitions, cut, copy, paste.
It
It is to be written, now it's cut, copy, paste.
My lord, sometimes it also becomes very important.
Yes, that's your submission.
Sometimes it also become, and here, my lord, I find that is not only, my lord, in one paragraph 29, but also, my lord, is being again supported by para 31.
How you look at it.
Now, my lord, so far
There's no other alternative efficacious remedy. It's your submission. Mr. Mojumdar is saying other thing. He is not admitting that.
Now, my lord, with the deepest of, yes, the way, my lord, that we look at it, and it is my deepest of respect, my lord, that I do not find, my lord, this maintainability point, my lord, can be at all addressed by the private respondent 12, so as to, my lord, oust me from this. And, my lord, so far these judgments are concerned, asset reconstructions, my lord, with my limitations, I have distinguished. This L. Chandra Kumar, I say, my lord, it only being applied, provided I have a remedy under the said act.
That is why I told you it may not make submissions on this, but since Mr. Mujumdar has relied of it.
Exactly. Now, my lord, so far as the other judgment that your lordship has, my lord, yourself has delivered in case of Gaur Chandra Ghosh, that only, my lord, follows this L. Chandra Kumar, and, my lord, says, my lord, that and affirms that it's in a way of supplementing. So, my lord, no other, my lord, thing, my lord, that may, my lord, required to be looked into, my lord. This is the only thing, my lord, that your lordship was considered, and this is, my lord, well settled, my lord, thing. Now, my lord, at the concluding, my lord, my submissions, I just show, my lord, 2-3 portions. My lord, my learned senior friend has shown, my lord, L. Chandra Kumar, para 81, 90, 91, 92, 93, 98. 99. Now, these all says about that a grievance under a specified statute. Now, may I just address this? It is something more than an effective alternative forum. Is something more than an alternative forum. Well, if Mr. Mojumdar's submissions would be effectively made, then, well, I have only that forum only and no other forum. It cannot be said that effective alternative forum, or that could be that forum may, well, adjudicate my grievance. I even do not say that. If this L. Chandra Kumar applies by my learned senior friend, well, it could be submitted that, or it may have been submitted that my court of first instance has to be there. But if I am not wrong, Millard, this submission was also made that it could be an effective alternative forum or an alternative forum where I could go and seek the remedy. This is not my case. It is not that I have chosen between two. I have only one forum before me.
From the very inception, you are saying that.
Exactly.
Your only remedy lies before the High Court.
Exactly.
And no other forum.
Exactly. Now, Millard, so far as para 21 and para 23, read with Millard, my supplementary affidavit, page 6 and 9.
Don't place the facts.
No, I am not placing.
Paragraphs you have placed.
No, this point is that I declared that it is not a minority institution recognized. But I even do not say that. I say that I impart education the students who are mostly minor. And in
Article 30 protection you don't need. Article 30 protection you don't need.
my lord, kindly looks into, my lord, I say Article 29 and 30.
Yes, yes. How does it come here?
My lord, if your lordship permit me, protection of interest of minority. Any section of the citizens residing in the territory of India or any part thereof, having a distinct language, script, or culture of its own state, shall have the right to conserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state fund on the ground only of religion, race, caste, language, or any of them. Now, here
We are not deciding the aid, other things, education. That's not the subject matter in
my lord,
book one.
this come within the, my lord, ambit of protection of interest of minorities. My specific case is this.
Also, we are not on that admission, how it is managed, how that institution is managed. Article 29 and 30 with regard to that. We are not deciding on that.
No, we are not deciding. But
So,
what I am saying that in my specific case, even in letters, I have shown to your
29,
lordship.
30 does not come to your aid here.
I have shown, my lord, in my letters to the state, of West Bengal, lordship has looked into already. I say it is a only girl student. It's from a backward area.
That's
If
a
I
different
could
thing.
not, admit them.
29, 30 do not come to your aid.
My lord,
29, 30 subject to correction do not come to your aid. It's on a different concept altogether.
my lord, then a school which run with mostly of the minority students, my lord, the right to education, my lord, they, my lord,
Not the issue now. That's not the issue here. It's not the
my lord,
right
it would be the direct effect. The school has to be closed down.
that you have to move before another.
The school has to be closed down.
That's a different thing.
And here, my lord, I state in
the consequence. That's not the subject matter of this writ petition.
And I
whether you get that land or not, that's the only subject matter. You are trying to expand it to that level. That's not the subject matter. Article 29, 30 don't expand it to that level. Because those are different concepts altogether.
my lord, this is my submissions. I leave it to my lord's kind wisdom. I only concern, my lord, I said in very specific that there is also problem since it's a backward area. So in a very, my lord, low age, my lord, at a very minor stage, my lord, they are being, my lord, given marriage. So, my lord, if the schools are there,
Not the issue here, Mr. Basu. It's not a public interest litigation.
no, my
It's
lord,
not a public interest litigation. Whether the school can have 1 acre of land or not, that's a different thing altogether. What will happen to the students, whether they are giving marriage or not at a low age, that's not the subject matter of this petition. Yes, anything more, Mr. Basu?
no, my lord, nothing more, my lord. May I just conclude in 1 minute? My lord, my principal prayer, my lord, is to, my lord, see, my lord, and have a judicial review over the departmental process for not granting me, my lord, that 1 acre of land, which is an essential ingredient in terms of, my lord, the rules, my lord, in force to have a
Provisional recognition
and also to have a playground. My lord, this is my cause of action and why I am before your lordship. My lord, so far the lease deed is concerned, my lord, I have principally nothing to say against it. Now, my lord, so far as lease is concerned, whether it is to be modified or cancelled or to be, my lord, annulled, my lord, that is to be considered by your lordship, my lord, under the judicial review, considering my need, my lord, how and where, my lord, and why it is at all needed. My and this, my lord, concerns, of course, my lord, my legitimate expectations, why I needed this and why I need
that
this.
will come to if on after the maternity, I will come back to this.
And here, my lord, if I may also join that if today, my lord, is a question of, my lord, this so far as our rule 53 of the writ rules concerned, my lord, it says, my lord, whenever the CPC applies, if the writ rules are, my lord, silent. Now, my lord, in that case, my lord, if my learned senior friend submissions are to be considered, it's a case of a rejection of plaint or a case of a return of a plaint. That since, my lord, my writ is not maintainable over here, this court cannot hear this matter. This, if order 7 rule 11 sub rule D, my lord, barred by any operation of law, my lord, if it is to be considered that in other way around, that it is barred by the operation of law. Now, my lord, is operation of law, in which sense, my lord, is West Bengal Land Reforms Tenancy Tribunal Act. Even if I go to or think of that aspect, my lord, nothing is shown to that aspect, that section 4, which says about any decision, there was nothing. And
section 6.
Section 6.
my lord, section 6.
Tenancy Tribunal Act,
No.
section 6.
If your lordship looks into section 6,
So section
yes,
4 of what? Section 4 is
position.
to cite
Land Reforms Tenancy Tribunal Act.
section 4. What is section 4?
But that is constitution of the tribunal, I believe. Subject to correction. Section 4.
Yes.
That is constitution.
Section 4, what do you want to say from this?
Section 6.
Yes, that is why.
Any order, I stand correct. Any order.
When I said section 6, that is what
No,
it also struck.
my lord, I mixed up with section 4B. Section 6, any order made by any authority under a specified act, in an application complaining inaction or culpable
Not
negligence.
your case.
Not your case. Now, my learned senior friend has shown, my lord, D, applications relating to matters under any provision of a specified act or matters relating
This
to
is
any.
disjunctive. You need not go to the second part. First limb only.
Only the first part. Relating to any matters under any provision of specified act. I do not have also that case. So this is my submissions, my lord. I would be beseeching, my lord, this matter may be hard on merits.
Heard the learned at
Have a nice lunch and sleep.
Lunch.
he thought that it will be over by what?
What time you take your lunch, Mr. Majumdar?
Sorry,
On Sundays and
My lord, I take lunch by 1. 1. We all thought that we will go back. Grateful, my lord. My lord, I am not going to come.
Thursday will not be coming.
No. Thursday and Monday, very difficult.
I think on merits I can fix it on Thursday. Yes, Mr. Basu.
If your lordship comments, I will come. Mr. Chakraborty will take.
No, request Mr. Majumdar, if you can bring him, I can hear it.
No, I would bring him. If lordship directs, I could.
Bring him.
If lordship directs, I could.
And I tell you, lordship, Thursday, because the elections will be held tomorrow. Thursday, there will be a lot of difficulty regarding parking.
Thursday?
No,
Yes.
that is the same thing today also.
That's a difficult proposition. And
Today
4th of May, my lord, I think no advocate would be able to come. 4th of May will be very difficult. Counting because
that will be.
Yes, I tell you, lordship, because my lord, if anything untoward happened.
Untoward, ki untoward.
If anything untoward. Untoward in the sense, my lord, not in the sense of, my lord, some kind of violence, some kind of disruption, some kind of, which usually happens during any election.
Indoor Stadium is the main counting for Calcutta, then all the versus political leaders, their followers will be there gathering. So it's possible for us to come.
Malad, one very important point to note that
30th many can come, 4th May it is impossible.
But one very important point to note, Malad, I have been watching Malad national news, Lordship also does. They also, Malad, took a very serious note of the issue that after independence, possibly this is the first time in Bengal, there has been no reported violation on the first day of election.
No, there are.
But those are
There are
not being reported or not being found out, except one death which is being, well, a particular
That's a
political leader
different-
done in
there are
Asansol,
two
but
reported
no violence.
No
No reported violence.
incidents of violence, one in Nauda and another in that
Very less.
very less.
But very less. At least no means
But
very less.
that is
Not in the
that
usual
is
course.
North Bengal and part of
Compared to what happened in Panchayat election, last parliament election. But tomorrow, yeah, maybe touch wood.
we will all hope that nothing happens.
What is
But my lord,
happening in
4th of May, my lord, your lordship knows that my lord,
this entire area will be blocked.
একটা মামলা চলছে তো চিফ জাস্টিসের ঘরে
কি নিয়ে?
ওই to this blockade of this all high politics.
Opening the counting system, sorry. Counting. Then with the declaration of results.
Counting people and the countless number outside the outside the counting
Extremely
center.
grateful,
Extremely
Man,
grateful.
38 I was praying.
38, where is your other?
Man, I contacted him, but he has left.
Yes, left.
Yes. 1 week more extended.
But yet also no one will come.
Yes, that's why. I
Please
tell
inform him.
extended for 1 week or 2 weeks.
Please inform him.
Yes.